Good morning or good afternoon, depending on where you're at. I am your host, Bob Mata, and this is Defense Diaries podcast. This is our continuing coverage of the insane Karen Reed case. I am super excited today because my friend, the brilliant legal mind, the dashingly handsome with striking blue eyes, former prosecutor, host of Closing Arguments and Vinnie Politan Investigates, is coming to hang with us to see what the hell is going on in this case today. So without further ado, let me bring him on. What is up, brother?
What's going on? Good morning.
Not much, man.
Good morning.
Thank you for joining us.
For this podcast, I gotta kick it up a notch. I gotta be a little bit smarter.
I think you're plenty smart. Plenty smart, brother. So I noticed I love these hoodies you wear. I notice I think your favorite is probably the allegedly. You like to wear that one. That's my favorite one of yours. Gives me a real defense attorney vibe. So you can imagine I would really enjoy that one.
But it serves two purposes because it's it's a big legal word, but like in the world of legal journalism, I mean, for my entire career, we're walking on eggshells trying not to defame anyone. All I do is cover people who've been accused of things, and I've got to modify the way we talk about them. So it's always allegedly, but it's interesting because the word depends upon how you say it, right? Like you can say allegedly, or you can say allegedly. As soon as you do allegedly, all of a sudden now,
right? Tone and tenor is everything, man. Tone and tenor is everything. No question about it. So yeah, no, and that's true. That's true because that is a reporter that has to become part of your lexicon, like where it's just instinct.
That's when you get fired, Bob. That's when you get fired.
No doubt about it. All right, so we're going to be throwing Vinny's links up in here. You've got an amazing YouTube channel. That link's going to be over here. So is your channel called The Tangent, or is the Tangent podcast like a separate thing that you have going on the channel?
Here's the story. So I do Vinny Live, which is just me by myself, but once a week, because I got to have fun, right?
Yeah.
It has to be fun. And when I say fun, I mean, having serious discussions, but then I'm having a little bit of fun with it. So there's two guys that I worked with when I did Court TV Morning on Sirius XM Radio. And we had the show for a few years. It would go from 6 to 9 every morning before the broadcast day on Court TV. And Jonesy is like a radio legend. He was sort of like the co-host and producer of the show. And then Al, who I'd known before that from another one of my legal shows, was he's a lawyer, and he was a regular guest for years on that show. And the most fun we had on Court TV Morning when Al would come into the studio. So,
stands to reason then.
Yeah. And all three of us are Mets fans. So
oh man,
we text each other like 15 times a day during baseball season.
Got to be pretty happy about that Soto signing.
Yeah, exactly. So we're in a good mood. So we needed, a way to spend time together because I'm in Georgia, they're in Jersey, and everyone's busy. So we said, once a week, let's get together, let's do something. And the reason I call it The Tangent, because our discussions, we inevitably go off on tangents. So we start in one place and we end somewhere else. Oh, look at this. You've got all the great products from the Vinnie Originale store.
I thought I would tempt people with your fabulous merch here, man. So you've got the Viva Las Tangenitas. That's beautiful. So that's obviously a tip of the cap to Tangent Podcast. You got this, rather morbid, but pretty awesome, outline of a body with the classic red rum. If you've seen The Shining, you know what it is.
We always have to modify what we say on the air, right?
We do.
It's amazing. Court TV is a broadcast network, right? Which means we use the public airwaves. So we are regulated by the FCC.
Right.
But I can say things on television, on public airwaves, that you can't say because of the snowflakes who run and the algorithms that run YouTube, Facebook, and other. It's amazing. Like if you say the one wrong little word, nobody's going to see your video.
I know they put a brick on it, and it's like, and I'm terrible at it. Like if I'm reading through a document and it's got essay in there, or if it's got the R word, or I really tried to train myself just to say homicide all the time, because I think that one's okay as opposed to the M word or red rum.
Right.
It's hard to know though, man. It's hard to know. So y'all, we're going to be dumping Vinny's links throughout the entire chat the whole time he's on. So if you guys want to head over to his store, pick up some of his awesome merch, definitely please go and subscribe to Vinny Live. He does great lives. You're getting a different Vinny. You got your Court TV Vinny, and then you got your Vinny Live Vinny, which I love them both. But if you want to kind of get to who Vinny really is at his core, you go to Vinny Live. That's where you're going to get all the inside dope over there. So
Vinny beneath the robe.
That's right. That's right. That's right. All right. So Vinny, before this thing starts, what the hell is going on over here, man?
This could be a bad day for the defense. Like we already know that the judge is not crazy about the defense, right?
Yeah.
We kind of gathered that a little bit. I don't think she's been as unfair as some people have accused her of being, but she is clearly, and we know this, right? Those of us who practice, that you go into certain courtrooms, some judges, will help the prosecutor a little bit more, and then once in a while you run into one that'll help the defense. And rarely do you have ones that are completely straight down the middle. It's just because they're humans. We're all human. If I was on the bench, I would probably help prosecutors more. That's just the way I am, right?
Right.
But I try to be fair, but inevitably I would probably help things that way, help them more, because that's my filter. And I think Judge Cannone is the same way. But the way she ended the last hearing, talking about grave concerns about the defense and the future of the defense. I think the biggest risk here for the defense is Alan Jackson, because he is not licensed in Massachusetts. So it's sort of a privilege to allow him to try a case in Massachusetts. So I think that's most at risk. But I think we're in the same space. Like if you're the judge, you got to be real careful about kicking defense attorneys off cases. We saw what happened in Delphi. We know how that works. But that was a different scenario. Here, I think the allegation is that they lied to the court, they misled the court, and they duped the prosecution when it came to these experts. Now, I don't think there's going to be an agreement about what the facts are here, about what exactly was said, whether money exchanged hands between the experts in question. Now, these experts were supposed to be independent experts hired by the feds, and then the defense just put them on the stand because their conclusions helped their case. And they said to the court, these are unpaid. We didn't prepare them. We're just putting them on the stand. We don't know what they're going to say. And the prosecutor is saying, wait a minute, this information that we have now, and I think they got it from the defense, by the way, but this information we have now shows that there was an invoice for $23,000, that there were some communications about the substance, the content of the testimony, not just logistics. So that's, and I don't think the defense is going to agree with that characterization of it. So I'm wondering how the judge will determine the facts here. Are lawyers going to be put on the stand and put under oath? Are they bringing in the expert witnesses? Have they been subpoenaed? Do they have to appear? I don't know how this is going to go down.
Yeah, that's kind of the mystery about how this thing is going to happen. I agree with you. I think that it's easiest to pull somebody's pro hoc vice. Like that's the easiest way to get rid of any lawyer. Like you said, though, the Sixth Amendment ramifications are massive. I mean, we're talking like, because Alan would not go quietly into the night. Like we know that he would fight, much like the guys in Delphi did, to get back on, and they were in state. I think that Judge Bev would really have to, she'd have to have a hearing to get him booted. She'd have to give some cause as to why. I don't think she could just pull his ticket. And I agree. I mean, I fully expect that there's going to be issues if Yannetti, Jackson, Alisi, and Little don't walk into that courtroom today with receipts as to what the hell went on.
Yeah.
You know, because we got the money issue. We've got the issue of the communication between, you know, the ARCA guys, and particularly Wolf and Jackson, where, you know, we saw Hank Brennan literally reading from a script from, you know, about the direct examination that was going to be upcoming in the trial. And there was some back and forth there. So I think those are going to be the two major issues. And, you know, timing is everything with respect to the communication between the ARCA guys and the defense. You know, if this happens after the voir dire took place, after Judge Beverly Cannone said, look, I'll let him testify. I think in terms of them being able to communicate just some kind of basic concepts in terms of this is what we're going to kind of go through in terms of your background and everything else without getting into the substance of what he's testifying about. I think that that's okay. If there's anything relating to work that they did prior to, which is when this report was made, because the DOJ hired him, it could be a problem. It could be a problem as long as because as far as I'm concerned, you know, the report, it was independent. Like you can't make the kind of the issue is that you can't sit there and champion the fact that they're independent, that they're not a hired gun by either side. And then you've gone after you've said that and represented that and tried to tailor their testimony or get them to change their report. So, I mean, but how she's going to do it, dude, I have no idea.
Yeah.
I have no idea how she's going to go about it.
She needs to, because they're not going to agree to the facts. So there has to be some way to figure out what happened here and whether or not you judge credibility, if it's just going to be all documents and digital communications. Now, we took a look at the timeline last night on my show. And from the allegations, this is from the prosecutor's perspective, there are communications in March involving a retainer agreement. And so I'm wondering, that's March. That's like way before all of this. So that's kind of, I think you got to figure out what exactly is going on there. Then I think the biggest problem they may have, and this directly relates to what you were just saying, is they're saying he testifies on Friday, and on Saturday, like Friday's the preliminary thing about his you know, who he is, et cetera. Right. And then on Saturday, there's allegedly an email from the expert to the prosecution and some discussion about testimony and what he's going to say or what he
mean to Jackson. So that was the email, between Jackson.
And that's on Saturday, and then he's back on the stand on Monday. So I think that's a potential.
I mean,
problem.
It depends on what he's talking about. I mean, like, you're
talking about what he's going to say on cross-examination,
right? Like if he's asking him to change his opinion, like the whole thing about, you know, where Brennan's like, oh, you know, he's sitting here. There's a note where they're discussing, you know, that the most prevalent time that pedestrians get struck by vehicles is at night. Well, first of all, duh. I mean, you don't need to be an ARCA expert to know that. But, you know, he then testified to that in open court. So that wasn't withheld from the state. It's not like you need to do a lot of research. Once he asked the question, Lally was going to have the opportunity to, you know, cross-examine him about it. But moreover, I mean, that kind of helps the state anyway, the Commonwealth, in terms of the guy saying, yeah, you know, people typically get hit more at night because you can't see them.
You can't see him.
You know, so, yeah, it's going to be interesting. Like Jackson's in peril.
I don't know if he's appearing in person because last time
he's appearing, dude. There's no.
Are you sure?
Yeah, there's no way because there was that whole conversation towards the end of it. He's like, I've got a hearing on the 24th. Like, I mean, like he has to realize that, you know,
how serious this is.
Yeah, this isn't a hearing you're going to appear via Zoom. Because when she said you may appear via Zoom, I'm like, oh shit. She's like, you don't even need to show up, dude. So I was.
You don't need to ever come to Massachusetts again. Is that what she was saying?
Yeah, exactly.
She said grave concern, and to me, that's the real problem.
Yep. I mean, she was super pissed. But I mean, we have to think how much of that is from kind of the issue where we've got Brennan. All right, let me pull it up. I thought isn't this the live thing here?
This is live.
Can you guys hear it?
I do not hear it.
All right, hold on. So you cannot hear it?
No.
All right, hold on. Let me pull it off. I'm going to pull it back on. It's got to be StreamYard. All right, we got. Okay. All right, tell me if you can hear it now.
Took a recess.
Perfect.
We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCA witnesses testified. There's another email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not 1, but potentially 3 witnesses that you never talked to. I looked back at the June.
Am I alone?
Jesus.
I
don't know what happened.
I was alone. I was alone.
Were you scared?
I didn't know what happened.
So
Sorry.
3 weeks
Hit
ago,
something.
not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit.
Man, she
And the
sounds.
third reason I paused, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel
Okay.
to all of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with Your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you, bring it up?
A court officer will take it for you.
Okay.
I appreciate that, Mr. Lessie.
You're welcome.
That's a big notebook.
Sure is.
There's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay.
I can feel the tension here, Bob. Why is that?
Actually,
Man,
I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you.
good,
Your Honor.
perfect. We can talk.
Wow.
Man, so
It's not going to be a good day for the defense.
You
that
unmuted.
grave concern thing still seems to be very much in play. she didn't sound like she had cooled her jets much. Like like, and Vinny, you know, from your days back as a prosecutor, you know, you try to read a judge in terms of when they're kind of given their, you know, their admonition of whatever they're going to be talking about, or they start getting into their rationale of a decision they're going to make. And as the attorney, you're sitting there, you know, if it's a big ruling that they're making, you're sitting there trying to figure out what the hell she's, you know, the judge is going to do. And like, you know, so when you sit there and listen to that, I mean, she sounded like they better have some receipts or there's going to be hell to pay. That's the vibe I'm getting, man.
And the way she said, if you want to say anything, almost as if you have the right to remain silent.
Right.
I mean, that was the way she was saying it. This is, I guess what I'm gathering from her is she's going to use the transcript and whatever communications as the finding of fact, whatever sort of like emails or text messages that she has. But I've got to think that there's a little more to it, that the defense has to sort of fill in some of the blanks and explain whatever these things are and put more context into the communications right? The transcript is what it is. You could watch the video also. You don't need a transcript. You can watch the video, but of what happened in court and what was said in court, to me, the facts that aren't clear are about the communications, the text of the communications. And I'm wondering if the defense is going to sort of fill in the blanks, and if they have any additional information, or if it would have to come from, statements from people who made phone calls or who can explain what this text message actually means.
Exactly. I think that it is going to boil down to the issue as to whether or not they were prepping these guys and what that preparation was in light of what she read, in light of the portion of the transcript that she read regarding Jackson's statements in open court, that we haven't had any communication, we haven't prepped them, we haven't asked for them to change anything with respect to it, we haven't asked them to do any more work. That's, I think, where this thing lies. I think that's where the issue is going to be for her. I feel pretty secure in light of the fact that Alan Jackson, after court last time, doubled down and said, we didn't pay them anything. I don't think the money thing's going to be an issue. I mean, you can't control if ARCA thinks they're going to get paid and they send an invoice. That's not on the defense.
They always get paid. That's their standard operating procedure. You want me to testify? This is my business. Like, this is what I get paid to do. I get paid to come into court and testify. So maybe they're just sending this stuff out, presuming that that's how it's going to work.
And it's interesting that they're having Elise kind of rep them. It typically in situations like this, like in Delphi, Vinny, when this whole removal thing was, it seemed to be like it was in play over there, and they had that hearing, if you want to call it, where Judge Bev, the only time, which I know you've taken great exception to with respect to that trial, allowed cameras in the courtroom, was that day. And everything took place back in chambers, but defense counsel, even though there was nothing pending, there was no motion for sanctions, there was no sua sponte motion for removal, there was no due process in that the defense was not given notice. Okay, you might want to get representation. These are the allegations. You have an opportunity to answer for them. Instead, she says, come on back. This is what we've got. If you want to have an opportunity to withdraw, I'll allow you to do that, or I'm going to go out in open court and I'm going to pants you. And they both, Andy withdrew and then Brad later caught it. So, well, let's see what's going to happen. I'm going to try to boost it a bit.
All right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yes.
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of the facts. I also believe that the chronology is going to address many, if not all of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns. But my intention, Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor. And because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so are you were addressing this in chronological order as well, right?
Yes.
So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them,
Sure.
but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes,
Yes,
your number.
I will tell you exact
8.
pages that I'm going to refer to. And Your Honor, get to this is tab 8
Right.
of the notebook.
Mm-hmm.
And specific pages that I'm going to reference start on page 53.
Okay.
And those are 9 pages that proceed all the way to really the substance ends on page 62.
Okay.
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to suspend
You
my
can,
brief or keep going?
no, you can keep
Okay.
going and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should be good to at least start.
Thank you.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay. All right. Go right ahead, Mr. Lessie.
Thank you, Your Honor. So I start with tab 1, which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts, but I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the ARCA report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as Your Honor will recall, the trial 1 started in April of 2024. So it was pretty close to when that trial started. And I know Your Honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report that the vehicle, and the substance is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Ms. Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or defense, had access to ARCA. They had the opportunity to contact ARCA. There were restrictions that I'm going to get to on that contact. But either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know, but I understand the facts to be that the Commonwealth didn't make contact with the ARCA experts. The defense surely did. So that is the background, that is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, the rules of the road with regard to the ARCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your Dr. Rentschler's and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was
Was the federal protective order that was referenced by Mr. Yannetti that said it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, I wanted to say, I'm going to answer it directly. What Mr. Yannetti articulated is the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCA experts, okay? That was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation, but I do not know the answer.
All right, go ahead.
And it's an important question, important answer, I understand. But I'm going to give you information that's going to indirectly answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email. And my understanding is Mr. Yannetti is not knowledgeable about these communications. So the email reads, "Hi, Alan, subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly inchoate at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is, I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCA is willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the ARCA experts in his opening?
I did not review the openings. I reviewed only for the non-evidentiary transcripts I reviewed was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the ARCA experts because the defense didn't even know if they would be testifying. The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get there.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th.
Right.
And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening. So that pause continued through the opening. That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I am going to hit head on these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire, and that the ARCA witnesses were going to have to come up from Pennsylvania, and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from ARCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar, these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, These experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court. And it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question.
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes. And I want to key in on you've never spoken, right? To and putting them on the stand. Now, no one ever said from the defense they never spoke to them. But that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes 2 people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says, that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background. And I've got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. And I know the immediate response might be there. It might be at this point, wait a minute. You haven't had time to interview, et cetera, et cetera. But what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is now fighting with bringing them in for a voir dire. That's Mr. Yannetti says that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get to how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3. And it's the June 18, 2024 voir dire examination of Dr. Wolf. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right? I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was said in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lap. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism because the Commonwealth had the opportunity to interact with the ARCA experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell. That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight, and Monday morning quarterbacking, would have asked them.
That was a scratch. It was a scratch. I apologize, but I had an itch and then I forgot that that's the signal. So I'm sorry.
It's an earlobe tug.
It's got to be a full Carol Burnett.
Oh,
Exactly.
so he's saying no, not I got it. I got
Like,
it.
no,
right,
that's not a tug. It's a scratch, Jerry. It's a scratch, not a tug.
But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But
Sounds
I
like there are
get
some.
to the prejudice, and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages, not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf the questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility and pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask. And as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email, but it's important who it's from and who it's to and who's not on. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face. And one of it is you can always tell what goes along with the email. So this is attachment Wolf Qual's document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I was well aware of that.
Okay, so he prepares it. He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please
Pause it real
turn
quick,
to
babe.
the attachment, which are the qualifications, etc.
Did you want me to pause it?
Yeah. So he's made this point multiple times about Yannetti not being privy to these emails. And she mentioned reading the closing. So clearly something, I mean, all I can glean from that is something Yannetti said in the closing is at issue. And it seems like the defense is sort of laying the ground for an excuse for whatever that is. Would you agree, Vinnie?
Yeah, there's absolutely something going on. It's a big point. And what I don't like about the way he's presenting this, like, it's very detailed, but it's like we're reading a mystery novel and we're trying to figure out where he's going. And I don't think that's the best way to make an argument. I think it's great for producing a video, producing a documentary, but for making an argument, like, give me the arguments off the top and give me the framework so everything you say now connects to all of that. And he keeps saying, well, I'm going to get to that. I'm going to get to that. I that always frustrates me. It would frustrate me as a judge too, to figure out where he's going. But
And it definitely leaves me thinking there's something, because he didn't know. There's and her comment about just reading the closing seems that she found something very significant in something Jackson said in that closing that's at odds with something now.
Yeah, and it's interesting because, Alisi at this point in his career is basically an appellate attorney. You can tell by the way he addresses the court. But to Vinny's point, when you have if you're going in for oral argument on an appellate issue or various issues, you always state your issue first and then you address it. So it's like issue, argument. And to your point, Vinny, he's not really making that connective tissue obvious to the judge at this point. He's kind of going through all of the evidence that he has, I guess later, maybe to wrap it up. I do think it's significant that direct transcript was prepared by Wolf. That I did not know.
Right. That's the other part of this is what's his end game here, right? Like what is is he going to get to the point of, all right, this is why we didn't do anything wrong? Like you got to let us know off the top. You can't, it's not a page turner. Here's the other question I had for you two from all your experience. And I have my own opinions about this. Have you ever seen a judge change their mind?
Very rarely.
It's very rare. Like their mind is made up. They come on the bench, people make their arguments and everything. But I saw it once on court TV, and it was in the Robert Blake trial. It was the preliminary when the defense attorney, who was the guy who ended up being Michael Jackson's attorney, George Washington. What's his name? He looks like George Washington. I forgot his name. Great attorney from LA, like great attorney, but you could see the judge change his mind on the spot and dismiss 2 of the charges, like right there. The judge had no intention of doing that. But I don't know about Bev. I mean, it's a heavy lift. If she has her mind in one place right now, and I think we all know where it is, she has grave concerns. Can he do enough to change her mind? And I think he's like trying to do it with an aha at the end here.
Right. I agree with you that it would have been best for him to start right from the front. Like, we're going to show, we did nothing wrong. We said nothing incorrect. There was no payment. There was, but who knows unless something has been said to them between last court date and this court, where the judge is like, this is what I want you to focus on. But you can tell she's still on one. Like from the jump, when she was like, when was this prepared?
Yeah.
Like she wanted
to
know.
Irritated that she didn't get it ahead of time.
Right. Right.
Yeah. No, I mean, like any of us that thought this was potentially a nothing burger coming in, that this is not a nothing burger. I feel like I can feel the tension. You can hear a pin drop in that courtroom.
And his build-up's making us think there's something there.
Yeah.
Watching this as an attorney, I feel anxiety.
Right.
Like, it's crazy. It's crazy. All right, let's keep going.
Let's do it.
Back up a minute,
There's
like one blip.
Comment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor.
All right. Then what you all up in arms about?
The next tab, and of course, it has the D&T of Dr. Wolf's experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth. with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Welf to Alan Jackson. Subject Wolf Direct, attachments, Wolf Direct. So it's clear, and then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARCA, the frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the rule 14. And we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson.
I always
now I want to get to the timing because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you.
All right.
So the other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation trying to figure out what to ask Dr. Wolf under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire that this could have been brought up, all these topics in
Pause it a sec, babe.
voir dire. Not that voir dire satisfies all Rule 14.
If it's truly an outline of his qualifications and his trial and deposition work, that would have been in his curriculum vitae. It would have already been turned over. I don't know. Him making the argument this way is as though it should have been disclosed and wasn't, when he started with, there's nothing in here that hadn't already been disclosed by way of the report in the first place.
I think he's trying to cover both angles. So, but like he's articulated finally what he perceives as the issue, that there this 1 day time frame between when he receives the direct testimony transcript from Wolf to the next day when Wolf is taking the stand, that he thinks that the judge thinks that might be the Rule 14 discovery violation in that 15 hour period, in that Jackson didn't turn that over immediately.
All right, I think he's making a mountain out of a molehill, and he should have started with, similar that he did, there's nothing in here that hadn't been disclosed. So from everything I can tell, this does not fall under the rule and would not be a violation. But let me tell you this other information.
What would happen though if the shoe was on the other foot? If
Right.
it was a prosecution witness and a prosecution witness provided some information, the defense didn't get it.
Yeah,
That'd
I'd be
problematic.
pissed. Yeah. But if it really is just the qualifications and it's the same information that's been disclosed, I mean, that I've had plenty of times where the state has an interview of a witness and claims nothing new was said, and I don't even get a report about it because they say nothing new was said. So isn't that the same thing?
Potentially. I mean, the bigger issue is this isn't just a witness. This is the witness the defense, by their own account, considers to be the two most powerful witnesses, namely Wolf being one of the most powerful witnesses, who they believe contain, exculpatory information in their reports. It really highlights who these guys are and the import of them to this trial. So I think, they're not character witnesses. They're not just lay witnesses. They're coming in with the heat. I don't know. We'll see.
These are the not guilty. These are the not guilty witnesses that they need.
Right.
Although the jurors completely, just ignored them because they didn't understand where they came from. So they didn't trust them at all.
Right.
14 obligations. But the reason I here that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think, perfectly tailored to the situation, to basically say, I don't, as the court, understand, these folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of it. We got the report, and all we had is emails in March, right? That are, in my view,
oh, these are the
not
direct
substantive
examination
communications.
questions.
They're Rule 14 material, no doubt, Your Honor. But the question,
You got to give me the high sign.
Sorry, so this is after the qualifications, because it sounds like, remember he said, I'm going to put together some direct examination questions. So that's what it sounds like he's talking about there, which would be different than the qualifications, but he also did say it's everything that's in the report. But
Well, this is, yeah, right. This is the script. This is the direct examination script that they're talking about. But I still thought initially on the 13th of February that Jackson had prepared that and sent it to his witness. Today, we learned that it was the other way around. So
Right.
this is more than just his qualifications. This
right,
is
I get it now. Yeah.
Okay.
Question is what's the prejudice, right? That are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up. Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, you know, a great deal of my work is in the field of lighting and visibility. So there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is again by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Little? No, that's correct. Mr. Yannetti? No, fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question, when did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer, correct. Question, and that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer, correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say, this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway.
We didn't pay you.
Haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct.
There you go.
And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with a March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement. to the best of my knowledge and my review of all these facts and discussions with counsel. So then the next, that's correct, question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson asked, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. And Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation, but I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having, but he's got to go on the stand with his professional reputation, and he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will not.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor. And I
If
said
you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I
Okay.
think the only way to fairly...
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So can I say for certain? No. Can even Mr. Jackson say for certain? No. That's the sense, though, that was extant at that particular time.
Okay.
So we then go down to the next question. But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding. Yes. And you were equally available to both sides in terms of them reaching out. Correct. Yes. And I called you ultimately after receiving your report and asked if you join us and testify. Correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARCA. That was Dr. Wolf's sense as well. So that is the direct testimony of Dr. Wolf. And I want to just speak to the findings because on page 3676 to 3677, because the findings never changed one iota from the report ARCA issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings and you're going to deal with the findings that they have. So what were those findings? Bottom of 3676, line 25, did you perform an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes, I think that's a fair characterization. And reversing that was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle. So it's important to know in terms of, you know, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, you know, the findings of ARCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice. But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial. Right. I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, these are recollections, information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation?
Babe, pause it.
As I understand it, one of the questions of Mr. Deitch was,
So just so everybody knows, and I know we made this clear on another live, if the defense had agreed to pay the expert before, at any point up to the time that they testified, but then didn't pay them, you cannot ethically put an expert on the stand and say, he has received no compensation. He's not being compensated for this. I haven't paid him, knowing and planning to pay them later.
Pay him later, right? Can I have a cheeseburger, today and pay you on, Thursday, right?
Okay, Wimpy.
Yeah.
I'll gladly pay you for I'll gladly pay you Tuesday for a
that would be a definite, clear-cut, black and white ethical violation. It would have been a lie to the court and the jury. So obviously this explanation, we had all thought it can't be. It must be a bill for this upcoming stuff. There's no way. But we'll hear the further
Well, it's
explanation.
significant. He just stated they didn't pay him anything. They still haven't paid him anything. As from what I understood.
They haven't paid him. So it really comes down to a couple of things, right? There's March 20th, Jackson agrees to the engagement letter and the retainer. Now there's also a phone conversation that's not memorialized anywhere, right? He sends the email after the conversation, but does the email contain everything that was said in that conversation? Like we were talking about before, Bob, like how are we figuring out the facts here? Like we're getting no testimony. We're getting no sworn testimony. We're getting emails, but there was also a conversation on the phone. So we have no idea exactly what was said there. And I wouldn't presume that there was, but it seemed on March 20th, there was some agreement for an engagement letter and a retainer. The amount we don't know, the terms of it we don't know. But then they say that again, this is the uniqueness of the situation, is that in the middle of this relationship between the expert and the defense is the U.S. Attorney's Office. And then they say they're the ones who put a pause on everything because of the bizarre situation. Now, I have to believe like their report and everything was paid for by the FBI and whoever was investigating. So they put a pause on this. So it's just forgotten and not addressed ever again, according to the defense, up until the point that they send this bill.
Right.
But this guy's an expert. Now, I don't know how much the expert knows about the rules of ethics, but he's testifying that he's not paid for any of this.
And we also don't know how the billing works in their
Maybe
practice.
just automatically. Maybe he's covering himself because that's they always send a bill, right? There's always going to be a bill, but this is such a unique situation. Is the bill a product of the internal workings of ARCA and the way
I have a feeling,
for their time and their testimony? Oh, so someone in accounting sent out a bill, right?
Well, I'm assuming that Wolf turns in his hours in terms of whatever expenses,
timesheets. It's timesheets.
Somebody else who's like Wolf's not sitting there typing up invoices. Like that we know for certain. So I agree with you, Vinny. I think that probably was prepared somewhere within that organization because they probably have an entire department that handles their billing. So,
right. So I'm sure he's about to get into all of that. So
well, let me ask both of you. Do you think it would have been more effective if they just would have had Elise direct Alan Jackson on the stand?
Possibly.
I mean, let's go right to the horse's mouth. Have Elise direct examine or cross examine, whatever you may want it to be. That may have been a better approach.
Wolf should be here.
Wolf
should be here.
I think he should have either gotten an affidavit from the state's attorney that they should be offering testimony about that conversation that he just is saying to the judge. I want you to call the U.S. attorney and ask him these questions. I think some of that, or an affidavit, from.
How do you get Wolf here, though? Do you call him? They went right back where we started.
Yeah, exactly.
Yeah. All right. Let's keep going.
Let's hear what he says. Do a 1 5-second
What was the
backward.
substance of the conversation? Because as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, the date of the invoice is July 12th. And I think I can get you the exact dates here. Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July 24th date?
Get you an exact answer.
I would like that.
Pull the damn check. So pause it, babe.
I'm going to attempt to get an exact. If I can't, I think I can get a good.
All right, you guys have to turn your mic down. I have the screen boosted, so our mics are cranked.
All right. So is this better, everybody? I just turned mine down some. Let me know. But while people were waiting for people to let me know, he did say, now I'm sure they're going to get into this, that somehow Jackson didn't even know that this payment was made. It was through his billing department communicating with his client. I don't know, but Jackson said to the press last week, no, we have never paid those witnesses.
And Elise articulated that again today. Like 15 minutes ago, he said they never paid them anything.
Well, that was him reading the questions from at that time, they had never paid him anything. He was reading the direct. So he said that was true.
Yeah. Well,
so wait, what did people say about my
I don't know how to turn my microphone down, so I'm just going to move away from my microphone.
Well, if you click the settings button at the bottom and then you click audio, there's a box at the bottom that says automatically adjust. If you unclick that, you can move it down. I put mine at 50.
I'm at 46. Because with the boost,
I'll see you at 46 and I'll go down to 44. There we go.
All right, cool. And Mandy, don't play clips because they're blowing people. Like
Bukkake.
Those are too loud. They're too loud, Mandy. All right.
So this is now problematic on two fronts for the defense. They paid the invoice. That's bad. And they admitted that, yeah, this was Rule 14 material. They should have been turned over, but there was no damage done.
I'm surprised they admitted that.
Yeah, Bev's not going to, the judge, I called her, why did I call her Bev? The judge, I never refer to judges, except Belvin Perry, America's judge. But this is problematic. And I think the biggest problem is going to be Alan Jackson. I think another reason why they may be separating Yannetti from Jackson is so she can keep half of the team.
Yeah, I mean, it's
not
how
good
he did not have that answer. And I'm talking about Elise immediately seems evasive.
Yeah.
When she asked him, like, how do you not know?
Right.
Like, do you not know that she's going to ask, when was that paid? Oh, I don't know, but I can get it. Like, it seems evasive because you know why? It is evasive. Like
Yeah.
he should have absolutely had that date. It was paid. You're going to have to make the argument it was for expenses, and then you're going to have to battle that out to see if that was allowable.
Yeah.
under
And
the
no,
ethical rules.
Karen would have paid it to the firm, in my experience. The only way to do it, because you're expert to retain that attorney relationship, has to be paid by you, not by your client. So, but the client pays expenses separate. So it is possible, and I'm sure we're going to hear further explanation, but like we've been saying from the beginning, like this whole separation of Yannetti is like, all right, Jackson did do something wrong, or somebody did do something wrong. Did Yannetti say something wrong that he didn't know, or
I don't know, but you're right, Allie. When Elise was specifically noting the fact that Yannetti was not CC'd on these emails, he was clearly carving out the fact that Yannetti wasn't in the know.
right, but I
So
don't know that it's about the payment. I think it's more about the communication. So
I think it's about all of it.
I think it's both. I think it's, yeah, this is major, major problem for
Wow.
the defense.
I mean, this is an issue.
all right, let's go get the check there, buddy. Come on, you guys need to have it right there. This is ridiculous. Maybe she did pay it. She's the one looking at her bank statement.
Your Honor, I understand a check was sent to ARCA on July 25th.
Thank you.
You're welcome.
By? She was the one pointing
So
out.
there's no doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, what the facts, is it came out of the blue. And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question, and it's important, very important question.
Babe,
But it's an important fact point as well that call was made.
so I answered the question that no, Karen wouldn't have paid this directly. It would have went through the law firm. And he did not say who paid that directly, but she was looking at her tablet,
Yeah.
scrolling through and pointing to something. So is it possible that the office called her, said there was this bill, and she did pay it directly? And if so, why isn't he saying, or is he eventually going to say? Is it like Vinny said earlier? Is he waiting for an aha moment? Because I find it odd that
Yeah.
Well, I mean, now we know why Elise's going through these. I mean, whether we like the style or not, we now know why he's going through this the way that he is.
because
There are problems here.
He's
right?
very defensive in the approach. Now, he keeps saying out of the blue, right? And it's not really out of the blue. Because on March 20th, Jackson agreed to an engagement letter and a retainer. Now, there was a pause, but there was that agreement. So it's not completely out of the blue. It's not like there was never a discussion about money. There absolutely was in that phone call when you go back to March. Now, there wasn't the follow-up. The engagement letter, I guess, wasn't signed.
it
They
might not even have been sent, because he said
right.
something is, and then
Yeah, but there was a phone conversation about money, that this is going to be, you're going to pay us. You're going to pay us for our time. There's nothing wrong with it, but it's the opposite of what was presented to the jury, who ironically disregarded it anyway. And that made them trust it less because they didn't know where it came from, right? So that's a huge problem. I think
an
that's a huge
engagement
problem.
letter for everybody out there is what starts the relationship. It's I was trying to highlight the person's question that asked what it's an engagement letter. That's like, here's the terms of our it's the contract. It's the terms of engagement. This is what our relationship is. This is what I'm hiring you to do. You now work for me. which is why they said they didn't work for them. They didn't even have an engagement letter.
I mean, they were paid after he testified. So, you
Right.
know,
And the
I mean,
defense
but-
is affirming that they had, despite all the points Vinny just made, that at that point in time, they had no anticipation that a bill was coming, which to me seems absurd when you're dealing with travel expenses. Like, how could they not have thought that they were at least going to have to cover travel
Right.
expenses? But
So
yeah,
how-
this is dire. This is dire. I'm starting to get the sense that Alan Jackson is going to be removed.
so
well,
the-
let's hear that.
Let's
Oh,
hear it.
Is
Wait, Vinny's
there an
got-
agreement though? I mean, if there's an agreement, an oral agreement is just as enforceable in certain circumstances
100%.
as a written agreement, right?
Yeah,
So-
if they had known they were going to pay, like actually known, not like, well, we talked about payment, but then it got paused and we never had an engagement letter, no retainer went out. If there was an oral agreement, just like we said before, yeah, we'll pay you, bill us afterwards. That is an ethical violation. That had to be disclosed. That is still compensation, you know, in relation to their
But clarify
testimony.
that it's an ethical violation because they put the witness on the stand and had him testify that he had received that ARCA had received no money for them testifying there. That's what creates the violation.
Right. And all lawyers know it doesn't matter when the bill goes out and the check gets paid. If you have agreed to pay them, you have to disclose that, and you cannot ask that question and make it seem like, I mean, that's a known, it's been dealt with, it's been addressed. There's no pulling that fast one, and we all
All right,
know
let's
that.
rock and roll. Let's rock and roll.
So in terms of the next tab, which I've been alluding to during
Okay,
my.
so this is the one I said I needed to take a
I
recess
was
to
just
read
going to
that.
say the same
All
thing.
right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
Hey, perfect. We've got some blips. We've got some time built in.
You are muted.
Well, I don't know, guys. Babe, do the blip.
Yeah, we don't have
Bloop,
15
bloop.
minutes, but
No, we don't. Bloop. Oh, Pepperpot was asking before we restart, can we go back a little? They wanted to be reminded what his last statement was there.
we what?
Go
Oh,
back.
I still don't understand why they continue to have everything in this tiny courtroom. Next to it, there's in the same building. There's only a couple courtrooms in this building. There's this huge, beautiful courtroom where members of the public could see the public trial, and it's actually the Sacco and Vanzetti courtroom where that disgraceful prosecution of those innocent Italian Americans took place many years
All right,
ago.
so yeah, we're gonna be close. Yeah, so Vinny, babe, was he was telling me I need to get out to Canton for at least portion of this
going.
trial.
You got to go.
I'm like,
You
you
gotta go.
convinced me. Yeah, like, man,
Wait, I want to ask you guys something, as I wasn't here at the beginning, and it goes into Grant's question. Did she say something in that? What did she say in the beginning about what issue is going to come up that she was going to need a recess to read? Did she, was that on the record?
we don't know. It was something lengthy that was
It must
contained.
obviously has to do with this payment, because he wasn't just shifting gears completely. I'm done with the payment.
I mean,
you know.
why is Jackson walking out of the courtroom on the 13th and telling the press that they unequivocally did not pay ARCA?
Yeah, that's weird.
That is.
I mean, does he not know what does the left hand not know what the right hand is doing over at his firm? I mean, it's possible. I mean, it's a big firm. They're a very high powered firm. If invoices are coming in, they could just be getting paid. But you would think
But there had to
whoever's
be a
handling the
conversation.
billing, right?
But they had the conversation about should we pay it? Like, who
Right.
had-
Right, and
so
they disclosed the bill. So to me, I am still going to be shocked and floored if Jackson knew that bill was paid. It's just makes it.
Then how do we not have him on the stand? That's what I'm saying. I think Alan Jackson, if he wants to have any chance of staying in this case, he needs to get up on that stand and answer some questions, I think.
All right.
All right, I
Grant's
think we're-
asking again. Payment happened after trial, so someone tell me why this matters. Now, I don't know if you've been reading the chat or you just got here, and I say reading the chat, so not listening to the words we've been speaking. But the issue is you cannot have an agreement to pay someone and just tell them to send your bill afterwards. I'll pay you when you send it. That is something that needs to be disclosed. You cannot have this workaround. Now, if he in fact, despite the points that Vinny made a moment ago about, well, there was at least some initial discussion about their billing, but then there was the pause and the engagement letter, the terms of their relationship, the fact that they're agreeing and promising to pay the witness, all that would be in the engagement letter, that the engagement letter never went out. And I would say the fact that they did not request a retainer, because Vinny, I've never, ever had an expert do a damn thing without at least getting an initial retainer, even for like review of materials and consultation. So
Right.
I do think without the retainer, without a signed engagement letter, that he's thinking at this point, we're not involved with them. We're not paying them anything. They want to stay completely and totally separate. However, I will say, I if there was no discussion about the cost of travel, I find that odd, because I can't imagine a world where you think someone's going to pay their own travel fees to come testify for you.
Yeah, and room and board. It's not happening. All right, they're back. Let's go.
Wow. Oh, thanks, Jay.
May I proceed back to the podium, Your Honor?
Please.
Would you like to remain seated?
You can
Thank
go
you.
back.
May I continue, Your Honor?
Please.
Thank you. So, Your Honor, to blend and quickly summarize what we've gone through, I'm using the table of contents of the notebook. We've spoken about the March 20 and March 22nd email from Mr. Wolf to Mr. Jackson. We talked about June 10th and statements of counsel. We talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolf and the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf. July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor. Now to the transcript. And as I go through, I start on page 53.
Okay.
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCA as a witness was made 5 times. I counted them, and we'll go through each one and number them. Or deprive the defense of an ARCA expert in this case. Very important, because my perspective, what was put in the firing line on February 18th was the ARCA experts, albeit indirectly. So now we go to page 54, and this is going to be, in some points, a line by line, because the words matter. line 5, and this is again is Attorney Brennan.
Mhm.
Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the ARCA experts? February 12th report? A voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it biased, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that that expert is biased. But this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office in their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word.
All right, Vinny's got a dip. He's got to take care of his blood sugar. Hey, man, we love you. Thank you so much for the hang. And let's do it again.
Anytime, anytime. Bob
All right,
Mata,
brother.
ladies and gentlemen. Bob Mata.
Vinnie Politan. Sub over to his channel. Go buy his merch. Thanks, brother.
See you later.
All right, man.
Because it gets really important. When there are claims made that the defense has not turned over something and there are words used like
Hey, and Vinny, nice seeing you.
duty,
Oh,
it's
gone.
important to understand
The man's
get
got
behind those
his.
words as to what the
Oh,
facts are.
I was behind time.
So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination.
Okay.
Really? Voir dire occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5.
Babe, pause it a
The
sec.
Commonwealth is not saying we have an issue with.
I want to hear this.
Sorry, I was watching on my phone, so you guys were like slightly ahead for me popping in saying bye to Vinny. I just want to say there was a part where he said he made this whole to do about how he said, was there any collaboration or incentivization that they didn't know about that they couldn't ask about. And he kind of twisted that to be they didn't know about the experts. And that's not what Brennan was saying. He was saying, you know, was there collaboration? Did they have communication about the testimony that he was unfamiliar with? Did they promise payment that he didn't know about and couldn't ask about because he was told it didn't exist?
Yeah,
But
I hear you. All right. Yeah, Vinny had to go. Blood sugar.
Yeah.
Plus he's always got short time frames. All right, let's go.
In ARCA, and why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense, and I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance. And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before, but his comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on, and he, on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55. Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you my impression from what is stated here is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information. So they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCA could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds, when he really got it from the defense? There's email correspondence between the defense, but not only the defense and the federal government, but the ARCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection. There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here. That didn't come until the invoice came in July. And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So next on page 57, line 11, he reads, response, hi, Alan. Subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I am going to please ask you to turn back to tab 1 of my notebook, because this was a purported quote of the March 22nd email. That's really not close to what the email says.
Is he doing this for dramatic effect?
It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt, because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter, and unfortunately, sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, now it's the opinion that troubles me. It's relationship, and the Commonwealth should have an even playing field. That's number 4 of the time he's not having any trouble with the ARCA experts. Saturday, June 22nd, Daniel Wolf wrote, Alan, I spent some time this morning putting together a brief outline of my qualifications, blah, blah, and this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, jury requests, and an insistence, the best I can to get as much information as I can. It's incorrect statement number 2, and it's an important one. Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. My, that's not a fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll start back up at 2.
Okay, Your Honor.
Right. Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea? And I'm not rushing you. Do you have an idea? Because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question.
She's not taking any lawyers off.
In 45 minutes, because I have to get to the law, the 3.3A. I have to.
I'm not rushing you. I just wanted a
That's
time
my
frame.
best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock.
You are muted.
Damn it.
Yeah, we're not behind time anymore. So
he
yeah,
never did circle back to the bills, and I'm left still wondering who knew what and who paid what.
So if the invoice comes after trial out of the blue and they call up the U.S. Attorney's office and say, hey, do we pay this thing?
I kind of would have anticipated an email or a conversation with them saying, I didn't know you were going to be billing us, but I guess they figured whatever, just pay it. It still does not, because it sounds like that call, did he say, does anyone in the chat know, did Alessi say that Jackson made that telephone call and was told to pay it? Because that goes even more to his comments to the press after court, which are not at issue in the courtroom, but they're at issue in my head. Right, babe?
Yeah. I was reading a tweet back from Andrea. So
Staffer, wait, so someone says he said it was a staffer. I think the staffer was making the call to the client about the bill.
But here's the question, Allie. If nothing happened. Like, to me, the only issue that would have existed is if there was some kind of agreement, either oral or written, with ARCA prior to Wolf getting on the stand and saying, we are getting no monies. We have received no monies. We've been paid nothing at that time. If there was agreement in place prior to that, that's where the issue lives. If they get an invoice after trial and the defense calls the U.S. Attorney's Office, said, hey, man, do we pay this? Like, why is that an issue?
I don't think it is. If they had, if it was a surprise, like he said, I don't think it's an issue. I'm just taking issue with the fact that Jackson said to the press after court, I said, that's not the issue
Right.
before the judge. It's just an issue in my own mind. Why in the hell would he be telling the press again that there was no payment made? And she, Karen was the one looking at the at her tablet. I don't know if she has some access to office records, or she's looking at something that the defense can look at as well, or if she had pulled up her like literal own bank records. But I don't think we should be left wondering who paid. So the judge sent an email is what Alessi referred to. And are you telling me in the beginning of this hearing today, there was no reference to like what she said in that email? Because she clearly said what issues she wanted addressed or what she was planning on doing. Did you?
I kind of like to pull up what Jackson said after court to the press that day.
All right. Well, somebody send us text Bob and I a link. But no, go back to my question in the beginning of the hearing, because they mentioned the fact that the judge sent an email out. So after the hearing and before today, about what she was thinking and what she might do. Did she not mention any of that at the beginning?
She didn't really articulate it. She kind of went through why she was upset. She did not articulate what she felt the issues were.
And she said she was upset. Why?
Well, do you want me to go back and show you?
Well, I guess. I don't know
I
if
mean, I
everybody
can't
else
remember.
does.
Like in terms of, like, we've heard 2 hours of argument. I don't remember what Judge Bev
But
said.
the fact that she's saying that there's going to be additional hearings today, she's clearly not on the same mindset as she was. Like, we're halting everything until I address this issue.
Right.
She's ready to proceed to other matters. All right, everyone's saying yes, replay it. They all want to go back. I'll do it because I don't know what you're doing right now. Bob is clearly distracted. All right, let me pull it up. Were we on court TV? Does anyone know what were we watching, babe? Babe.
Eddie, good morning, Ms. Reed.
Oh.
All right. So.
What were you saying, babe?
Nothing. That's what I wanted to know. I thought you weren't getting it.
Oh, no.
Last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the ARCA witnesses, I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCA witnesses testified. There is another email that was 2 days before the trial and after the voir dire, 2 days before the trial, with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor.
All right, so that's it.
I want to hear the rest of what she said.
We
Questions
will,
of
but the trial prep part, I think, is what's got her, because and again, like, there's 2 different things here. There's what we think Judge Bev might do and what we think, like, look, both of us have PTSD from dealing with Judge Gull, who doesn't follow the law at all. So if her mindset is that the invoice says trial prep along with costs and everything else, she has to be thinking
there was trial
that
prep.
there was some kind of conversation prior to trial about them paying for trial prep. Like, that's what, like, in her mind, that has
Right.
to be what she needs resolved.
And I think it was probably.
Okay.
With counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues.
She's already backing
not
away.
just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not 1, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can?
All
and
right,
I
pause
made
it, babe.
sure. So the transcript is of the entire.
Okay, so what we know now, That was February 6th, sidebar. They didn't produce the discovery until February 12th. So 6 days after Jackson told the judge, I have nothing else.
Well, it was 6 days prior to. So
Well,
they
I just said it in the reverse. I said that he provided it 6 days after he said that to the judge.
no, 6 days before.
No, he had the conversation with the judge 6 days before he produced the discovery. February 6th, sidebar with the judge saying there is no more discovery. They have everything that I have. February 12th, they produced the emails, the bill, all of that.
But so unfortunately, we don't have a transcript of that sidebar. I mean, typically
She just read it.
of the sidebar.
Yeah.
All right, let me hear it.
Oh, geez.
But when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14,
Wait,
and
you got to go forward
exclusion and
again so you can
preclusion
hear
of
what
a
she
witness
asked
is a
him.
punitive sanction for
She
Can't hear
so
you when the video's
okay,
going,
so
dude.
the other part, if you weren't listening, that she said was she was concerned about was said at are you listening? She was
Yeah.
concerned. I can't tell if your eyes are up or down. She was concerned with what Jackson said to her at sidebar when she specifically was operating under the assumption that there was a protective order in place and that the defense did nothing to resolve that conflict in her mind. And then if you just bloop back at like 5 seconds or so, she'll say, this is a question I asked you, didn't answer it, but when you did,
Bloop it back.
yeah, just 5 more rewind. Yeah. Okay.
a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said,
No, I still didn't hear the
I
question.
can tell you this. The Commonwealth is saying, pursuant to Rule 14, and exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense.
Have you reviewed Rule 14?
Yes, and it requires we went over it on our last live about this, where it requires that they reveal any sort of payment, incentive, anything at all. They and statements, but the key is, and Anesi, what's his name? Alisi made this point. Their obligation doesn't kick in until the Commonwealth files their certificate that they produce, but that's not what the judge is like. No, he was talking to me, not about my obligation to disclose hasn't kicked in yet, about the fact that he has produced literally every single thing possible, which is again why I think they should have been, downplaying the fact that like that email is discoverable. And I mean, I've never gotten an email that says something like, it was nice talking to you. I'm going to send out an engagement letter. Like that's not something I would ever expect to get in discovery. I mean, I trying to think on a civil case if I even got something like that,
Right. Well, that's what I was going to ask you. If isn't there language in the rule that to not that the discoverable items, if not tendered, would prejudice the Commonwealth?
Oh, you're
Isn't
talking
there?
about two different things. You're talking about a sanction and you're talking about the rule, just what's
Well, that's what I'm
obligated.
asking. I'm not
But
talking
for a
about two different
sanction,
things.
yeah,
I'm
they
asking
need
you a
it
question.
there needs to be prejudice. Yeah. They went over that last time and the court found the first trial. And the court found there was no prejudice or there was no intent. Was that at this? I could be mixing up my trials though. Um, well, why don't we let the people, what do you want to do? Let the people have lunch and come back at 1 o'clock, 2 o'clock their time? Or is it
That's 40 minutes from now.
2 o'clock their time?
I don't know. What do you guys think we should do? The other thing that we could do is we could, like, I still have every intention on watching that post conviction stuff, but like to kind of, I'm
It
talking
seems
about what
disjointed.
it does, but more disjointed than ending the stream.
I don't know.
It seems
See what
pretty disjointed to me.
JC Max says lunch, but
Lunch.
that's just one guy or girl.
All right. So, all right, that's what I'll do. I will, let me create a live real quick. Another one.
And Spitfire says she's in for post conviction. Tracy's in for lunch. We got a
Lunch.
dinner. We got a dinner.
Conviction. I
Is
mean,
it
I could keep the stream going. That's what we'll do. I'm like Allie and I are gonna dip. We're gonna go do lunch. If you guys want to dip, we'll just keep the stream going and we'll reconvene when the thing's going instead of creating a new stream. I think that makes the most sense. That always works. You guys can stay and chat if you want. If you want to go eat, if you want to go take a shower, all the things. So that's what we'll do then. That's what we'll do.
Cleveland says you'll lose a lot of people.
If what we stop the stream?
No, if we do, probably if you'll do, anyhow,
No, I disagree. We'll lose a lot of people if we stop the stream.
I think they all pop back up when the new stream starts, but
I disagree.
you're already
Wait.
losing them. Look at that numbers
No, they're dropping
dropping.
like flies. They're dropping
I
like
think I think you start a new stream, but whatever you want to do, you that's a you decision.
okay. All right. I'll create a new stream. Just hold on. All right. I'm gonna leave the studio chat for a while. Thank the people who put in. So I'm
All right,
trying to
people
get a
want to
wheel
stay.
going.
Just leave it open.
Yeah, I like stay.
All right.
All
Okay.
right. That's what I'm saying. Like we're gonna go off camera. I'm gonna go eat.
We're back
Y'all
at 2
do the
p.m.
thing.
Eastern time. Yep.
Yeah, like I'm gonna put it on so that it's live. I'm gonna put the court so that y'all are seeing exactly where we're at.
You can watch the OnlyFan.
Watch OnlyFan. Exciting. Okay. And then we'll be here if you're gonna go eat, you want to dip. I'm gonna keep this running. You guys just I mean, OnlyFan is very hypnotic if you just sit there and look at it. All right, we'll be back, y'all.
See the new chairs? Huh? See the new chairs? They're not new. New. They are? Yep. They have all stuff on What's that? They have all the fabric under them. Oh, yeah, that one's not, but two of them are new. Okay. They should get rid of the crap downstairs. Cut them off.
This audio is still live, just to let you know how the audio is live. Well, okay.
Want to sign back on? What's that?
Whenever you're ready.
What a nice thing that we can open the windows.
Welcome to Zoom for Government. Enter your meeting ID followed by pound. Enter your participant. Please enter the meeting passcode by. You have joined the meeting as an attendee and will be muted throughout the meeting. The host would like you to unmute your microphone. You are unmuted. You are muted.
The chief will make the call. Okay.
All right. So we're back. Oh, we lost 400 people. Nice. That could be true. Allie was giving me a metric speech saying that it's bad to have a dip in viewers. She's downstairs. She wasn't yelling at me. She was yelling to me. Oh, is there hot mics in there? Only fan. Oh, only fan. All right, I'm going to mute myself so you guys can listen to the court.
Why are we sitting here in silence?
Excuse me, Guy Vermectin. Get it right, dude. I am Gen X, bro. Proudly Gen X, the greatest generation of them all.
I mean, we
Gen
can't be
X.
boomers. Aren't boomers really old?
Not a boomer. My dad's a boomer. I mean, I'm old. I ain't that old.
Not that old.
Allie and I were sniping at each other quite a bit during our little lunch break. I think I was hangry. I feel like I can feel the food settling in. I
Good.
can feel it settling in.
Well,
You know what I'm
welcome back
doing? What,
to all the
what did
people.
what did we
Okay, I'm gonna
discuss? What
talk.
did we discuss?
Yeah, you're texting because it's
No, I'm
important. I
tweeting.
mean, you're tweeting because it's important. All right, I think it needs to be called something else. Do they call it Xing now? He
OnlyFan?
sent an X. I mean, what is it called?
Yeah, I'm Xing. So
No.
stupid.
He
I
sent
mean,
an
what else
X.
could it be?
No, but are people actually talking about like
It's like the
uses.
stupid name for his AI, like Grok. What is that supposed to be, like caveman?
I don't know. Grok is kind of cool.
Is
Like
it?
Grok,
It sounds like a caveman name to me.
but X, it
GROK.
makes no sense
I know.
because you had tweets
Tweets was
and
so cute.
yeah, and tweeting. Now I don't know. I don't know
Susan,
what
get
it.
your mind out of the gutter. Grok is cool. Grok sounds like caveman lawyer to me. I don't know.
I mean, isn't that little wooden guy Grok? Isn't like the tree guy?
No, that's you're talking about from that whatever that Marvel thing is.
Oh yeah, the
The little tree and the tree characters, whatever.
right.
Groot.
In,
Thank you, Afton.
oh, yeah.
Groot. Maybe that is why I'm thinking Grok is like, no, Grok just sounds like a caveman name. Just does.
I mean, it makes a good caveman name, Grok.
I imagine that
I Grok.
Grok was like Mike back in the caveman days.
But no, seriously, do people call it Xing? Is that, or no one does that? They still call it tweeting.
I mean, I still call it tweeting.
You want to make sure you didn't mute the court, babe. You're definitely live, right?
I am live. We are see that little red button? See that where it says
Mhm.
red? Yeah.
I do.
I mean,
Yeah.
all right, back up and running.
You are unmuted.
All right, Mr. Lessie, why don't you go ahead and continue?
Thank you, Your Honor.
Sounds quieter. They are really practicing their stoic looks. I think she's supposed to lean back to block Jackson's face. I'm telling you, that's
Go right
his.
ahead, sir.
He is
And take your
specifically.
time, Mr. Leslie. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I left off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court.
Yeah, babe, it
to
doesn't sound as
page
loud as it did
57,
before.
Line 11, where the Commonwealth said, response in quotes, "Hi, Alan. Substance to our conversation on Wednesday, the U.S. attorneys," and he's quoting the
How's that?
to quote the,
Didn't change.
and it's good to have, if Your Honor,
They
can
cranked
be
it up
having
on their
tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I dubbed the pause email,
Yes.
and because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept, because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57. 11, "Hi, Alan, subsequent to our conversations," he's quoting purportedly this email. On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off.
I think he said the word pause.
And it's unfortunate that that pause was not quoted.
Pause it.
On page 57.
Pause it.
Now back to.
I just want to say, I remember talking about the pause. Well, everything changed. That's when they paused. I wonder if it really could be the court reporter leaving it out. I don't know. We'll have to go back, like not through the live or on the live, but and listen to it, because I thought I heard a pause the first time around.
You did? All right.
Page 60, or excuse me, back to page 58.
Yep.
And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications. That's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery.
And you told me the 12th, right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts. So I want to try as my best. I may get some things wrong, but I want to try my best to be accurate. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth,
Okay.
providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
okay.
And
Go right
so-
ahead.
And so it would suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario, it was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th.
The
that
13th
this is set.
Thursday.
And
Do
what
you have a
is-
time?
Pardon me?
Do you have a time, Ms. Little?
Yes, one moment.
Thank you.
And I'm understanding Your Honor would like me to pause until you get.
Just
to the-
if we can, because I'm looking at a calendar.
It's the Thursday.
If you don't, I thought you may have had it. We can move on.
I believe it's approximately 6:30 in the evening. It was received by the Commonwealth.
Thank you.
And is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Ms. McLaughlin.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
So also, in big bold letters, at least on the printout, the subject is Karen Reed ARCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confer with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much. How is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement. We have two of them right up off the top, and then we continue on to page 59.
Babe, pause it a
Your
sec.
Honor, understandably says the court. What is the date of that?
I was trying to find the comment. Somebody put up the comment of pause being mentioned with the times. Oh, here it is. I'm wondering, mind boggles. I'm assuming that's you going back and listening to February 18th to see if Brennan said the word pause when he read the email. Now, I have read transcripts where I have been so sure in my head that I said something different or that there's something missing. And I'm like, I know sometimes I just can't trust my own memory. And I'm like, God, I really felt like I said this, or the judge said this, or something else was there. We've seen it now on two different things. If what Mind Boggles is saying is that he went back or she went back, yeah, okay. So Mind Boggles went back and listened to the February 18th actual recording, and Brennan did use the word pause. However, the court reporter, when she typed up the transcript, left out the word pause. And when he was making an argument earlier that there was something different and it wasn't substantive about the wording of the email versus what Brennan said in court, the email said, he said that he was going to attribute that to an error of the court reporter and not Brennan. That's horrifying to me, that in one transcript of a fairly short proceeding, there are already two mistakes. It's, you're muted, Bob.
That's
Oh.
true in terms of we do that a lot, where we think, when you're trying to go back and remember things that we think we've read or even said, it's, the mind is a funny thing.
Or the transcript is wrong.
Or but it's like we've seen that in the Julie Beverly case, where people that were in the court are saying that they know for a fact that things were said, but they're not in the transcript, which Lauren and I
And for those of you who don't know, Bob's talking about Murder on Songbird Road, the new podcast that he is on with Lauren.
Yeah.
Bright Pachenko. Is there another name in there, or was that all of them?
That's it. That's all of them. All right. Let's go.
Back it up with 5 seconds.
Okay.
Mr. Brennan, Your Honor, understandably says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So Your Honor, appropriately and understandably says, what's the date of that? Here's the answer Your Honor got. It's not dated. It's not dated. Now, let's please just go back to tab.
Oh,
We're talking about the outline. Let's go back to the outline.
he caught himself, didn't use tabs because she didn't want it.
And we could pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure you're, thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah, so that itself is not, I understand it's with the email, but it's not dated separately.
Well, Your Honor, I was going to get to that, but there's context for that.
Hey, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor. And I
So
appreciate the question.
what is the date of the, so you're saying what I referred to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one? When was
The other
that
one was
sent?
sent the day before
I know.
on June 22nd.
Okay.
I'm just going to give it the
Babe.
name that the email has. I think it's wolf_quals document. Okay? So there's two emails. One's just the quals. The other, I respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says.
Sure.
The title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual quals document or the direct document. We produced them in this fashion. And I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the
Agreed,
this is,
SJ.
important for the context. If you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I.
I'm going to ask you to hold that thought. I just have one other thought about
Yes,
this. So
please.
we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
And you are
correct.
saying that this was disclosed prior to the February 18th hearing. But was this disclosed prior to the witnesses' testimony?
He's
The
already
answer
said
is
no.
no, Your Honor.
All right.
The
That I
answer-
just wanted to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate.
Okay.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So
He's right.
now if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less, but blah, 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 blah. Now, here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then, yes, unfortunately, there is a direct
about right.
correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the voir dire. They had it 4 months ago, 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down the roadway, et cetera, et cetera. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, this is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65,
Okay.
line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know, a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents.
He's addressed
We
this already.
see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
Yes,
So-
she
so
told you
let's
that
go
like an
back.
hour ago.
That's misstatement number 5.
That was a huge
It would
mistake.
have been nice to have. I agree. It would have been, and you did. Twice.
No.
Next. Reading on the same page 16, he's quoting. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote. And then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree. And you had it twice. And then he
voir dire
comments,
trial.
if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry? What do you mean don't tell them? You were told twice in the voir dire and in the direct. It was just unvarnished. And here's the important part. Your
He
Honor,
said he
another
read the
important part.
transcript.
Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say? We're not. And honorably, Mr. Jackson, nope, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th, and the whole world heard it live. Next, if you could, Your Honor, please go to page 60. I'm sorry, there's another point at the no, let's go if we could. I don't want to take the lesser significant ones. I want to focus, because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2, and then a bill from ARCA to the defense for $23,925. That's not a trial by ambush. That's getting duped. So I, Attorney Brennan, didn't know any of this. But I've tried a few cases. I've been around the federal court a bit. I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No, you know about it because the defense, after the certificate of completion of discovery, and 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried amongst several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCA Reciprocal Discovery. That's not a very good way to try to cover up something. There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur? When was this bill stated? The date's important for that invoice. Then there's a lot of statements made. Sometimes parties pick sides, agree, blah, 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 blah. And then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion, it's a statement of fact. Statement about federal investigations that were there. These are not ghosts. We're not creating it, but I'm not going to go any further on that topic. But the ghost word was used to, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpreted as, you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line, page 60, line 13. I don't care if the ARCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with them. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and frankly of the moment in this trial. And the reason I've got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this and the court saying the break is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit.
In this case? Or are you just saying generally you've had this issue in other cases, or do you mean this
Other
case?
cases,
Okay.
other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break. So we didn't get an opportunity to stand up and say, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information. And I don't even want to repeat these words because it almost pounds on to the prejudice to the defendant. But Your Honor well knows what Your Honor said. But it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest, so be back in here. Unfortunately, that's not the end of the prejudice. So what happens is all of a sudden, and Your Honor basically said, and this is all so key. So you said, I'll see you in a week from today. And then Your Honor continued on page 61, line 12. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there, check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read? It was only then when the the reality hits that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds and the defendant didn't turn it over. So what does the Commonwealth do then? does the Commonwealth stand up and say, whoa, wait a minute, I've made a mistake, and Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake. My whole predicate for my whole presentation was I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped and I've been ambushed.
Babe.
Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court. I might have asked for a sidebar and come up and
The point still remains, and we talked about it last time. They didn't get it at the first trial, like that's the issue. But I do think out of all the information at issue, to me, even though I think Alessi is conceded more Rule 14 violations, is the direct. That's what we didn't know before. Was it just simply qualifications and trial, testimony and deposition, but the direct, um, which he's explained now. But when he makes these arguments that like about the extending it beyond like they had all this, they knew all this, they had it, they didn't have it at the first trial.
Wait, but they did because the voir dire took place before the first
Yes,
trial.
that's as far as, but no, I just mean the direct. And I understand his point. His point is we don't even know if he saw it, if he, like it was, I don't know,
See, but
someone said about 12 hours before he testified.
that goes to whether or not she's going to let ARCA testify. That doesn't go to whether or not
No,
Jackson's gonna-
that's a Rule 14 violation, not a candor to the court. That's what he was saying, not a
Right.
candor to the court
That's
violation.
what I'm not explaining it to you, honey. I'm explaining it to the people in the audience that,
Oh,
like those issues are going to go to whether or not she's going to bar some or all of ARCA's testimony.
but
Not
they can't. They've been disclosed it this time around. She
Why?
can't.
That's not the point I'm trying to make. I'm trying to make the point. I know that they can't, but I just want to be clear that that argument is pertaining to ARCA. There's two different issues. Remember, this wasn't a motion for sanctions against Alan Jackson. This was a motion originally to bar either certain testimony or ARCA from testifying. So, but
Right.
this
However,
turned out that we have both things going on now.
no, I don't think so. I think right now he is just addressing what the judge wrote in her email and just addressing the possible sanctions the judge may impose for violations of candor to the court and, and I
But
guess
candor
a
to the
Rule
court
14.
is as to Jackson.
Right. That is what they're dealing with right now. Whether
I
Jackson,
think that, but the Rule 14 violations, they're not going to remove Alan Jackson for Rule 14
right, but
violations.
she could sanction him if she wanted, I guess,
Well, yeah, but the sanction might be to bar ARCA from being able to testify.
I just don't, I disagree. I don't think she can do that this time around. I don't think she can do that this time around because they've been disclosed it. So that would just be penalizing, not evening the playing field for the reason for that type of sanction is that it's unfair to the state. Well, there's nothing unfair to the state this time around. So the only question is, does she take issue with their Rule 14 violation in conjunction with like the ethics of the lawyers as opposed to like a strict Rule 14 violation? Because I don't think there's a Rule 14 violation in this new trial. So talking about prior behavior is all her.
I mean, the
kind
only
of-
technical violation would be that 12-hour gap. And from when he gets the email from ARCA and then doesn't turn around and send it to Brennan right away.
Right. So the
As far
question
as I can
becomes,
see.
yeah. So the question becomes, does she think that that's worthy of some sort of contempt sanction, something, or piling it on to actually remove him, I don't think that she can even under Rule 14 prevent the testimony based on it because it's been disclosed in this trial.
Yeah, and look, there's two different ways to always look at things, and I think people have a tendency when like I'm saying things to think that it's my thought I'm always trying to look at what a particular judge is going to do in a particular situation. Now, I admittedly have some PTSD from Judge Gull, who followed no rules, who didn't care about the rule of law, who did whatever she wanted to do. And I know that there's a lot of people out there that think that Judge Bev is like hideously biased. So, like I don't tend to agree with that just based on what she has allowed in at the first trial in comparison to what Judge Gull kept out of the Allen trial. I mean, to me, when you're kind of comparing the two, Gull makes Cannone look like an angel. So, but my point being is that the folks that think that Judge Bev is so biased, if you're trying to think of it, and what I'm always trying to do, I'm not giving my opinion on what the law should be. I'm trying to give my opinion on what I think Cannone might do here. They're two different things.
Right. And
So
she still has an outstanding motion for the Rule 14 stuff that actually deals with the experts who are going to testify at trial. That's just not the issue she's taking up at this precise moment.
yeah, in Nordic, Brennan had said that Brennan needs to be held accountable. Right. I
agree.
mean, like we say that all the time. Like we're always waiting for these judges
February 18th,
to
right?
call February 18th for judges to call out the prosecutors when they pull shit like this, and it just never seems to happen. I mean,
No.
we've all talked about the inverted video and why she wasn't outraged about that at all. I
And
mean,
most
she
of you have
not
heard
only
the
even not
story.
like outraged, she didn't even seem mildly perturbed
Right.
or at all bothered by it. So it's like,
And it's
I
like,
mean, I guess as defense attorneys, we're accustomed to that, like probably more than the general public, but it doesn't make it right.
and we've told the story many times about the time that the judge screamed at me, if you're not able to prove this, I'm going to report you to the ARDC. I'm going to rah, rah, rah. And then he turns and says, and if she's right, state, I'm going to report you. I'm even going to report the elected state's attorney. And then after I prove that I'm right, there were no words of, nothing against the state
Yeah,
ever.
they didn't get
happened.
reported to the ARDC, nor did the elected state's attorney.
I mean,
Yeah.
It said, Your Honor, my bad. This is that. But that didn't happen. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, in the middle of a sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said the federal government, it was the defense. February 13th, they sent us the emails and the direct examination outline. I think I said that was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get them. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14? What was not corrected? It wasn't corrected that the invoice came from the defense. Just the emails.
I thought it meant everything, but
I don't understand how that conclusion could be drawn, Your Honor. It didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to
Why is she making
emails.
excuses for him?
So then we go
Words
to.
matter,
we
they
reach
don't
out
It's
to
matter.
the
because
pre-
I received a copy of it.
Pardon me?
Right. I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, and you got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard.
Yeah.
And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to
Doesn't
start
like
looking
being
at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this, being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again, because I was curious about the change in position on February 6th, that the contract was ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it, because that would naturally preclude the defense from retaining them. Yet at the same time, the Commonwealth, for the fourth time, has moved to strike our ability to use ARCA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements, 10, before Your Honor caused the pause. So coming to what happened then.
He's still got to get to the law. 45 minutes.
The Commonwealth, having not giving us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got, because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that, because that's allowed me to
Sir,
go
you don't
spend
have
the
to
time
tell me
I
that you
spent
appreciate me.
to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court and is inaccurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize Your Honors giving us of that week, and we've tried to take the best opportunity for it.
You're
So
losing
what
it.
happens?
See, that's why they got time
What
constraints in
happens
the appellate
after
court.
these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts, while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided.
One way to rectify
Had there
it.
been an
Remind me
accurate
when Bob comes back.
recitation of what had occurred. And Your Honor, I don't know if this can be remedied.
Yeah. Say
But it surely
FBI
shouldn't have
hired
been
ARCA.
exacerbated. I would now like to move rather hopefully efficiently through the next step,
I'm going
which
to try
is
to do this
to
efficiently.
point to the Massachusetts rule and give the court my view, and I have to reference because you're
Again, you don't have to tell me
tell
what
me
you're
what
going
you're
to do,
doing
Mr.
before
Leslie.
you
Just
do
go
it.
ahead
I'll
and
just
do
go
it.
ahead and do
Just
it.
gonna
My
fucking
apologies.
say it.
So now let's just
It's like,
turn
Bob,
to
I'm going to do this and pull this up. And I'm like, you don't have to tell us what you're doing.
So I'm going to go ahead and mute myself.
Wait, but pause.
I mean,
If
that's
had
just his
control-
speaking style. You know what I
Right. If
mean?
I had
Like
control
that's
the pause, I would have said, sir, you don't have to tell me what you're going to do before you do it, right before she said it. But when we're talking about this prejudice, which is real and significant, especially when you can carry it over to the experts themselves. Now, I mean, I guess the argument would be you can question them on voir dire. If they don't know about it, there is no prejudice, so we don't have to talk about it. But let's just pretend that we believe that there's prejudice, that there's jurors who've heard it, aren't going to admit it, whatever the case may be. Oh, Lord, I got to go get my charger. Goes back to what I've been saying, that they need to
why don't
ask.
you just go get your charger? Why
I
do you have
will,
to
but let me
tell us
finish the
about it?
sentence and then I will. So you can hit
You missed
play.
my point. I was poking back at you. Instead of telling us you have to get your charger, why didn't you go get it?
Oh, yeah, because I was saying after I finished the sentence.
Right.
Jesus. In any event, is to say that the FBI engaged ARCA and that they need that to bolster their credibility that has now been shattered. In addition to the fact that that the jurors discredited them altogether because they didn't know where they came from. But I'm just saying.
Yeah, no, I mean, you're absolutely right. And he's right. I mean, Twitter, or X which is the most toxic. I don't know what's more toxic, Reddit or Twitter. They're both neck and neck in toxicity. But, I mean, Wolf was getting flame thrown on Twitter, being called a liar is, they're like ARCA had to pull its ratings and reviews down. It's like, I mean, it's he's not wrong, which affects the ability of
Before you hit play, there is one other
Karen
remedy.
Reed to get a fair trial. I mean, there's no other way around it. If the two, what I feel are most important witnesses for the defense have had their reputations sullied, unrightfully so, in the public eye and again, remember, the public is the jury. The people that will be selected for the jury are in the public sphere. They're out there. They are probably somewhat aware of what is going on in this case at this point, as most of the world is. So it's not a stretch to think that they're not aware of what's going on and what has been said. And, the fact that Brennan was very, very sloppy. And the question becomes, was it intentional or was it just sloppiness? And we were saying that I took great exception to the fact that he misstated and doubled down on the fact that it was the feds that turned that stuff over, and then, doubled down and said that we got it pursuant to our TUI request. I was super pissed off about it because it makes it look like the defense is hiding the ball. I was saying that as it was going last week. I'm like, it's ridiculous, So
Well, I just want to say, point well taken. Giving her the gentle. I'm assuming you're going to hold each of us accountable to the same standard. But one remedy could be for her to say on the record, I find the defense did nothing wrong. I think she sort of tried to roll it back by her comments in the beginning saying, these are the reasons that I took the break. She knew it was important to clear that up, that this thing had gone just crazy and everyone was talking about how shooken she was and how enraged she was or excited. So I think that was like her way of kind of rolling it back in the beginning by putting that on the record. Although again, I did think she was still sort of on one in the way that she'd with the questions that she'd kind of chime in with, but she could go on the record and say, I find this to be a great defense team. Terrific. They're terrific. Um, of the utmost integrity, not all that, but she could just say something positive about the defense team to undo some of what went down last time. She could also reprimand the state for, at the bare minimum, not having its facts straight before it, tries to drop the mic and blow up the defense in her courtroom.
yeah.
All right,
Let's
bloop,
go.
when you do, bloop back 5 seconds when you hit play.
There was a gap.
Oh. Look, he's hiding behind her head. He really is.
Model Rule 3.3A1. And this applies to every counsel in this room, of course. A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by a lawyer. So we all know the mens rea of knowingly. And this court knows it better than everybody, so I don't have to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've
Talked
gone
about
through,
that at
the
lunch.
statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the notebook. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a misstatement, it happens, but you got to correct them, right? And what they talk about is, what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false.
Knowingly, right?
Of material fact or law.
And material.
And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. essentially what the case law talks about, that it's influenced the judge's decision. So
Did
let's
hear.
go back and even let's assume hypothetically that on June 10th, there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. In terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yanetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1. And as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit the one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs if Your Honor feels differently based upon what I've said, or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time?
So that's the sidebar.
I have taken the time. I appreciate the
Lunch.
offer. But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
Right, so I have that entire transcript, like I said. What page are you at?
I am starting on page 40.
Mhm.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the 2 prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with, no, okay, I received it. I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. Bugalton, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they've complied with Rule 14. And so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. But I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor obviously has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court move to exclude the witnesses. Mr. Brennan, yes. The court, what do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court, I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right, last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides discovery. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than waiting. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them, is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the US government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days technically to turn it over, but it got turned over on the 12th. 13th. So then it continues on, is important. The court, if I don't exclude it with other side seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided. The federal authorities provided all the discovery that was attended to their analysis and testimony. So
I've got a question for people that are not lawyers. When like an argument like this drags on for 5 hours at this point, do you guys have any clue as to what he's talking about? What they're still like? I think this is fascinating. I don't think he's overly verbose. I think this is a massive issue. It goes all the way to, the heart of a fair trial.
I think there's some things that he's repeating and dragging on about, but overall, no. And this whole
I wish he would have started with what he started with in the afternoon and the morning.
Yeah. Well, I want to ask you this though. Do you think the distinction he's making is fair? Like legitimately a fair assertion based on her, well, I'd say her reading, the judge's reading of the sidebar, but also the actual reading of the transcript of the sidebar, that
he's delineating between the federal and theirs, and since they hadn't tendered their
right. But flesh it out for the people so they know what we're saying, because
so he's trying to kind of quantify what Alan Jackson said in that particular statement to the judge, that we don't have any more discovery for him. So he's trying to go back in time and tell the judge, well, he didn't mean the stuff that we ended up tendering on the 13th of
which
February,
wasn't due yet,
because they had not given us their completion of discovery. They had not filed that. So, and he's saying what he was relating to was all the federal disclosures. So, I mean, I don't know. What do you think? I mean,
I don't know.
It's towing a line.
What I legitimately think is like this stuff that we're talking about right now is like nonsense. Okay, I guess technically some of it falls under Rule 14, but like the real shit, you have all the real shit. They're testing, their analysis,
the reports, all the real shit, exactly.
All the shit that actually matters. You have been, so I think in my mind, he's answering saying you've got everything that I've got.
You've
But
got the shit that matters.
right. But in fairness, I mean, we actually talked about this before, like when this first came up. Like, can you be arguing that, well, I didn't mean our stuff yet because ours wasn't due yet because they hadn't given the certificate of completion that is the thing that prompts the defense's requirement
Trigger. Yeah.
for reciprocal discovery. So, I mean, we were sort of pontificating that as a possible explanation. I just don't know, taking the law out of it and just human being it, is it really a fair, assessment of what he was saying?
I
And
mean,
maybe it is.
technically it is.
Technically it is. Legally
Technically,
it
but
is.
the law is technical.
Right. No,
But
I was
but
taking us out of the courtroom and just putting on our everyday person hat.
but
saying,
we're in a courtroom, so I think
yes.
in the rules matter, words matter, and the law
Right.
is
But
very technical.
also, for all we know, he's the one that put together the the packet. So he was like, actually did mean that and was fully aware that his stuff hadn't become due yet. But you'd think he would have said that as well. Like, plus our obligation hasn't kicked in yet for anything new because
Well, he said those magic words, we're not
right,
having this
we're
conversation.
not having this conversation.
So, but it's like you can't think of everything in the moment. And like
Right.
Elise so accurately said, we're human. This is a hard trial for a judge to sit in. It's hard. It's a hard trial for lawyers to try. Mistakes will be made. So you've got a way to exactly what your point is. The shit that matters, we're getting like bogged down in the morass of a bunch of bullshit discovery emails that matter not to the case itself. They have nothing to do with whether or not the state can prep for, or the Commonwealth can prep for the ARCA guys. It has nothing to do with that. It's a bunch of nitpicky bullshit when everyone knows that these reports were generated before either side even knew that ARCA existed. So like the thing that matters most, predates either side knowing that they were even doing the work. So when you get to this,
right. So when you're
and
talking
I
about
think
the discovery, that's really what's on your mind. That's like,
I mean, he's cured my biggest concerns. I mean, frankly, like, I mean, like you said, I mean, he did make kind of a tacit admission to a Rule 14 violation, but it's like a bullshit violation. It's not the type that would lead to removal of Alan
and it's
Jackson.
Rule 14 in the last trial.
Right. Right. Well, yeah, exactly. Because it was the freaking script. So
The direct and the qualifications, which I
Right.
don't see why he admitted that to be a Rule 14. But
I mean, she seems to think it falls under 14 for some reason. I don't know. We were saying that. I'm like, why? Like, in what world do you have to turn over your script?
well, but typically you're doing it on the phone and the lawyer's writing it, and then it's attorney work product, and otherwise. But what about the situations where we often have,
But we
where
thought
our
that Alan
expert
Jackson
writes
wrote it.
us?
Remember?
What's that?
We thought that Alan Jackson did prepare it when we first heard about it.
I don't
didn't think
think I did. I thought that I always thought that it was.
You thought
I
that
wasn't
ARCA
sure it was.
prepared the script?
I didn't think. I wasn't sure last time whether it was anything more than the qualifications, than that lawyer. I mean, than that expert putting together an outline of his qualifications and his depositions and trial testimony. That's
No,
I
you
did
didn't
not.
think that because he was going through the shit. He's like, oh, should we ask this? Like, you're just
He
not
said that was
remembering.
right. He said that was in a
Script.
no, in the margins. I don't know. We'll go back and watch it when we're not
Yeah, we'll
on a
go back.
live, but yeah.
All right, let's go.
What we have in terms, Your Honor, this is important, and I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production. goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided before, well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct, we had the quals, not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when. And so with regard to the shall not knowingly, there's no evidence of knowingly here. And I don't believe, respectfully, there can be an inference stated. When I've looked at every single case where the court can look at the circumstances. So knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances and, as the case law says, should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is, unfortunately, a woman attorney was in a bad divorce. She had financial statements, and she made misstatements of fact about her financial statements. And then the question became, did she knowingly know it? And what the court did is she said, no, I didn't know it. I didn't remember it. I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she didn't. So there's an example of, you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there.
What a stupid argument to follow his first argument that he was not referring to our discovery that was not due yet. He was referring to the discovery from the federal government, because what is the inference that Alan Jackson knew that he hadn't disclosed that stuff? You're telling me that he knew he got it, right? He knew he got these emails from the expert. So now what you're saying is he didn't know that they hadn't already turned that over before? I think that's a stupid argument. And everyone keeps asking, did Alan Jackson do something wrong or didn't he? And that's where I kept saying, let's get out of the courtroom and into just everyday life. Why did Alan Jackson tell the press we absolutely did not pay them? Why did Alan Jackson tell the judge they have every single thing we have? So and I think his first answer was a better answer. He's talking about all the federal discovery, not the discovery obligation that hasn't come to fruition yet for the new trial for the defense. What she's talking about is in the earlier trial, his failure to turn this stuff over. That was a Rule 14 violation. The script, which is really the only thing that I think is an issue, I want to call it the direct and not the script. It's an outline of the direct. Um, that should have been turned over, and an experienced expert should have known better than to put that in writing. And if Jackson had been really paying attention to these emails, he probably would have written back, "Don't email me questions you want me to ask you on direct. Let's set up a phone conversation," because again, then it's attorney work product. They're going back and forth, and but I who knows, then
Well,
maybe
I think that his answer is that he's at the point in his argument where he is fronting what he knows Hank is going to stand up and say. So, I mean, I agree with you. The much stronger argument is the one that he made initially, which is his head was in the feds. He wasn't fucking thinking about this other bullshit.
wasn't due
The
yet.
discussion, the discussion was about the shit that the feds gave them, and they both got the same thing. That's where his brain's at, like in that moment in time. I mean, you can't you have to look at that particular circumstance in a vacuum because it was. It's like you can't get into Alan Jackson's brain, but you can certainly, put yourself in a similar situation where the topic seems to be very pointed and you're not going to be thinking about everything globally, especially about shit that doesn't matter. Like it's completely superfluous discovery, which may fall under the guise of Rule 14, but it's not substantive. You know what I mean? It's not something that tips the scales for the Commonwealth either way. It's just a bunch of fucking emails between ARCA and Jackson. So, but I think what he's doing here is he's trying to front Brennan standing up. Oh, well, going back to that conversation, that sidebar, Your Honor, where Alan Jackson unequivocally said that we have everything. Well, we didn't have everything because these emails existed prior to that conversation, and he knew it. So I think that's what he's trying to do. I think obviously for you that the argument's falling flat a bit. I mean, to me, the bigger thing is that they've sent these things out immediately. I mean, like none of this mishigosh, none of this craziness was in existence at the point when they sent these emails out. So clearly there was no intent by Alan Jackson to not tender it over. You know what I'm saying? There's the gap in time where the proof is in the pudding. They sent them out on the 13th. As soon as they complied and sent their certificate of completion of discovery, we sent our shit out. You know what I mean? So, I mean, that exists in the world as a reality, which I think he should be making that argument, because I think that that's a more pointed argument. And I think that it really illustrates the fact that Jackson, at the point of whatever he said on the 6th, simply wasn't thinking about anything other than the shit that matters in the federal disclosure. Right. And the proof of that is that they immediately turned this over, and it wasn't in light of like this litigation coming, like, oh shit, I better, I mean, if you get caught with your hand in the cookie jar, you're like, oh shit, I better figure out a way to get this shit over to them. Like that, none of this had occurred yet. So it was clearly just like an honest disclosure that they were sending everything that they had left. And here you go. This is what we got. So,
and I want to address Kranken's comment, and thank you for your generosity. Can you explain why, after a mistrial, our system allows the negating of things in the first, like no crash daddy? In my opinion, fair is same with new jury versus Commonwealth gets a new playbook. So there is a doctrine in the law. It's called the law of the case. And typically, you don't relitigate issues that have been resolved in the earlier trial. How does that play out when you have issues not raised, like where they're making a different argument? And she says, well, Lolly didn't raise that in the first trial and they're raising it now. Like in Illinois, at least, if my client waives his right to a jury trial in trial A and he gets a second trial, he doesn't get back his right to demand a jury trial, which I find the most offensive thing in the world,
It's crazy.
especially when you think about the possibility of you've got a whole, sometimes you end up with a whole new judge it's being heard of in front of. And times may have changed. If years went by, the public's, there's all sorts of things that could,
Everything changes. That's crazy. That's like,
right.
I agree that is the most egregious example of that. Like, that's insane to me. Like, you should get the opportunity to go judge or jury if there's a
Each trial.
mistrial in years. I mean, typically mistrials don't lead to like more than a year gap before the next trial goes, but it can, depending on circumstances. But yeah, like, so much change. And in a case like this, like, imagine had she waived and decided to do, where it's so high publicity, where there's just so much chatter going on the outside. It's like, yeah, it's crazy. All right. Like, they're clearly not getting into any
And
more.
I haven't heard any law of the case arguments this second time around. I don't know if they don't really use that doctrine in Massachusetts.
I don't know.
But
We'll see. I mean, it seems like he's rapping, so I
I
sense like
wonder if she's going to have any questions afterwards.
I can't wait to hear what Brennan's going to say.
Yeah.
So and that's the February 6th, respectfully, that's the only aspect, and I went through all the others that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In sum, Mr. Yannetti's statements on June 10th, all completely accurate, Mr. Jackson's eliciting of the direct testimony at trial when he asked, have I ever asked you specific, questions, etc. That's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18th. Obviously, the Commonwealth is in no position to contact, et cetera, et cetera. And what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So if they can produce the discovery, I'd welcome ARCA. I want to repeat that.
You don't need to repeat it.
Okay, so my point is, we produced the discovery. Why is there still an issue with ARCA? These aren't my words. So I want to cover, before I get to the Sixth Amendment issues, the point that ARCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCA. So I want to touch that base to make sure that either intended or collateral damage, that ARCA still gets to testify, because it's a key part of the defense here. Now to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, doesn't correct it, the Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped. And I give Your Honor United States versus Gonzalez Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the
Is that counsel pro hoc vice, or is that not?
I'm gonna get to that. The answer is the counsel. I want to be sure of my answer. Yes, and I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it that says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure.
Yes, it is.
And then the following week, et cetera, and then the revocation occurred. And yes, it was. So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated below, where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in. It wasn't a revocation of pro hoc vice. There's a difference.
There is
obviously.
a difference, and both occurred in this case.
Okay.
There was both. Good point, both. So Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here.
Pause
It's
it.
only when the violations
Babe.
that undergird the pro
Pause
hoc
for me.
vice get repetitive.
I was just trying to text you. Where'd you go? You were in chat.
I know I had to get a drink and blow my nose and stuff like that. But the fact that she very quickly is
I
asking
know.
if
I know.
Gonzalez Lopez involves pro hoc vice,
I
she is
know.
still
I told
contemplating.
you. I told you.
I
Like,
just
people
can't
think
believe
that I'm
it.
like,
Still.
I told you. I was going to ask you, do you think, I mean, she has given Elise a very long runway here.
She keeps saying it's very important, so take your time.
Yeah,
It's
I mean,
very
like, look, we're always trying to take context clues from judges, and it's like you'll get the things where, we're making your argument, and the judge is kind of hurrying you along. The context clue is there, I've made my decision. You're in good shape. Shut the fuck up.
Right.
Here, she's giving him all the runway that he wants. Man,
As long as you need.
I don't know. But
And
yeah,
I
like
will note,
I wanted you to be here right when the Sixth Amendment stuff started. Of course, you were gone.
but
And
her
then, man, I
follow-up.
was like, just immediately says, was he pro hoc vice? Like, that's what, like,
Her
man.
follow-up question about Gonzalez Lopez was that for admission or revocation?
Right.
Mind you, it is a much more severe Sixth Amendment right to revoke your lawyer of choice, because that's your right to the continuation of counsel of choice, as
Right.
opposed to at the beginning where there is no, firm attorney-client relationship. There's no, like that's your lawyer. That's who handles the case. So her thinking there is totally wrong, because, and they did deny the lawyer's application for pro hoc vici in Gonzalez Lopez. I don't know if they also revoked a lawyer's pro hoc vici in that case, or if they revoked the local lawyers in that case, but I know they did
Well,
deny
he said both, that there was a revocation of both.
I wasn't sure of
A
that.
revocation of a well, he made it seem as if they did both, that
Right, I'm saying I
the
don't know if
judge
I
didn't
agree with
allow for a pro hoc to come in, and that there was either a pro hoc in there already that she then, or the judge then revokes. I don't know. All right, let's wrap this thing up. We got Julie Frew gave us a spoiler. This is like the very end of it.
Get more than repetitive, but go to things that are done that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong. Literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not for the trial the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. Well, I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore,
At least he really enunciates his T's like you do. Important. You're a big enunciator of T's.
conclude, Your Honor, and I would urge the court. What happened on February 18th? There were some misstatements and they weren't cured. I don't want this to turn into, and I'm not making this argument. I'm not making an equivalence argument.
Brennan.
I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I've provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say it as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we make mistakes. Mistakes have been made clearly by both parties. And I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare
But I'm
to
really
make
saying
sure
it's
that the
not the court.
presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said,
I might conclude.
if Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Yernetti, any questions Your Honor has, I would greatly appreciate it. My presentation notwithstanding, if there's still concerns with the court, we will take them on as best we can and certainly candidly. Thank you.
All right, I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
All right, good. Go to OnlyFan. So here's what I was going to say. For an appellate lawyer, okay,
You are
and I know I typed the words structural error, but did he ever say those words?
No.
I mean, this is such a significant argument. She is legitimately considering revoking her attorney's ability to practice law in Massachusetts, to removing her counsel of choice, denying her the continuation of her counsel of choice. For him to not have focused a little bit more on Gonzalez Lopez and the cases that have followed, I'm shocked. Not to mention the words structural error, which for all of you out there just means, and most of you know this because you were with us and continue to be with us on our Richard Allen coverage, but there's no balancing of hardships. There's no, was there a prejudice? Was there not? A structural error means you do this, deny someone their right to counsel, and the whole case is thrown out. We don't consider whether the present lawyer did a good job, whether there was an abuse of discretion. No, no, no. You do it, you screwed it, it goes over again. Period. The end. No questions. No
Yeah.
questions. So the other thing that made me giggle is like, if Brennan's citing case law about, I hope one of them's not the, Nebraska versus Allison Mata.
You're such a troublemaker. You're such a
Ugh.
troublemaker. I love when people on Twitter try to like put you
Yeah.
on blast. I'm like,
Like
okay,
we blast ourselves. So
right.
go
We're
off.
we're not like we're like my wife fights for her clients, mofos. So if you don't like it, fuck off. All right.
are muted.
All right. I think we have plenty of time to get right back to Judge
Bloop,
Bo.
bloop.
There she
Ah.
is.
Bloop, bloop, bloop.
Oh shit. Jackson's standing up.
Ooh, put your finger over the. Oh. Come on, give us 5 seconds, for God's sake.
You are unmuted.
You know I'm impatient.
You are.
I fast forward TV shows when it gets a little boring.
Try to give you my
All
gifts
right,
for my
before I hear
birthday.
from the Commonwealth, Mr. Alessi, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week. But actually, what I want to do, and you said I could
Next
ask
week?
questions of other counsel. So while memories are fresh, I just want to assure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yannetti. As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know and when.
No, what he said was entirely accurate.
Okay? Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
well, I'm sure the court did after it looked at the transcript.
No,
I did
no,
as well
no,
after I
no.
looked at the
I
transcript.
did long before I looked at that transcript.
The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript was very clearly the federal batch of information, what we referred to as the federal dump. I did not have in my head at all emails, communications, things of that nature. The small-
Invoices, payment.
No, nothing. I was, because the context of what Mr. Brennan was talking about being frustrated about were his TUI requests concerning the federal batch of information. And that's when I was making the additional statement, we don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is.
No, hold on. Ms. Little, it was just thrown on you that that you're responsible for all discovery, but the same question for you. And again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay. So I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
I still don't know who the hell paid ARCA.
Jackson's office, it sounds like.
I don't know why Jackson said that shit that he
I mean,
said.
I
in the
would
press.
assume that Brennan's going to bring up the fact that
Attorney
Jackson.
Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct in this case, you should
Why is he so
consider
quiet?
the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery
Now she's taking
violations,
notes.
representation violations. The defense in the first trial attempted and successfully did portray ARCA witnesses as wholly independent.
They
Presented themselves as oblivious to the nuances of ARCA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that, but it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the
use your
Commonwealth.
microphone, sir.
It is clear from a reading of the transcripts and the records and the posturing of materials that there was information that showed that ARCA was not wholly independent. Information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alessi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane.
I don't think so.
We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and providing information when the avalanches started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know for a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations sidebar. And those questions we're right to the point. And when we were sidebar, I specifically mentioned, I don't know, about there is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March.
There's only so much I could do. I've got the boost up all the way. Like, am I loud? How does it sound to you, babe? Like, for me, it's super loud, so I can't tell what you guys are hearing out there. Is it?
He's
How does
definitely way quieter than
Yeah,
Lucy.
I've got the boost up all the way.
Turn the boost down. I want to see if I hear different. Well, I guess
Here,
you'd have to
I'll
go,
all right.
but
So
loop
if I
forward,
turn it down,
just so we can hear the difference, but go forward so we're not missing
24,
anything.
and then
Or backward.
reinitiating on May 5th, where ARCA
that's
was
turned
actually
down.
billing
Now
the
turn it up.
defense for their works before the voir dire. There had to have been communication.
I don't think it
between
changed.
that time that rekindled this relationship.
Can you rewind
There
so
are
we're
jury
not
requests that
missing, like
are
hearing stuff for the first
mentioned
time,
in-
like while we're doing this?
What?
Rewind so we're not hearing stuff we've never heard while we're figuring this out, please.
Yeah, no, I'll go back.
So I don't think that it made a difference.
That's so weird. I mean, on my end, it's
That
like
happens
blaring.
to me. Right, that happens to me all the time. I hear it on my end, but you guys don't hear it, and I can
Here,
never
I have
figure out.
2 boosters. Let me try this other
Or
booster.
hit play so we can hear the difference.
Okay.
That is like a raindrop in a hurricane. We have a code of ethics and rules.
Are you doing
to
it
ensure
on
a fair trial
this
for
screen or the
both
screen where it's coming from?
sides. Coming in at the last hour
Babe,
and
What?
providing information.
are you
when the
doing it on this
avalanche
screen or
started
the
is
screen
not enough.
the sound's coming from?
I'm doing it on that stream.
Well, try it on this one.
Okay. All right. I think that other booster's better to begin with, though. I'm gonna turn this other one off, though. It's weird because
Then maybe switch to
he
somebody else.
sounded like Elise was standing at the exact same spot and he sounded fine, but I
Yeah.
didn't touch anything. All right, so yeah, I'll try to boost here. All right, so I'm gonna fire it up.
This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not
Did
to
it?
preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw your Honor's questions.
Is that
before
better?
voir dire, during voir dire,
Didn't
after voir
change.
dire. I remember the conversations sidebar. And those questions were right to the point. And when we were sidebar, I specifically mentioned,
You're
I don't
super
know,
loud.
a voir dire is inconsequential.
Turn the
I
one
don't know
off
what
on
to
ours.
ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed.
I'm going to
as
listen on Court
baseless.
TV.
Baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch.
Oh, yeah,
off
that's
the
way
tip of the
louder.
iceberg. It is not complete.
You're way too
There
loud.
is
You
a
need to crank your
murky
volume down.
All right,
relationship
pause it.
between the
You're way
defense
too loud.
Turn off
and the
the
United States
boost
Attorney's
on
Office
our
relative to
stream.
these ARCA
I did.
witnesses. And there is a very
I'm telling yeah, you're gonna blow out my speakers.
I'm whispering and it's down to 26. So you turned off the boost
Yeah,
on
on
our
ours.
screen. You
Yes.
sure? Because how did my sound change then?
I don't know. Let me see. Yeah,
Shut everything down and go to Court TV. I mean, my mic is down to 13 now. 13.
All right, speak now.
Testing, 1, 2, 3.
Okay, that's better. All right. All right, so
Shut
let's
down
see.
all the windows and open a brand new window and go to Court TV.
Here, I'm gonna let's just try this. You said it was better for him for a second, though.
No,
Oh,
Unclear relationship.
no,
As we stand here right now.
no. I
between the
listened on Court
history of
TV. It sounds
interaction
loud
between
and
the
clear. So, but
Uh-huh.
close the windows down and open a brand new window.
all right. So we're at. He just said raindrop and a hurricane.
Okay.
All right. Okay.
Bob's trying really hard not to narrate what he's doing.
Really hard.
I mean, I think we all want to hear it.
All right. So now I'm
I'm
gonna go to
wondering,
Court
is my
TV.
sound still? Is my sound still fine? Because I don't understand how it changed.
This sounds worse.
Mine?
Sounds echoey.
Oh, I mean, that makes no sense. I didn't do anything.
You guys tell me.
You can already tell. You can hear him.
Very echoey.
So what we're left with is we still don't know the relationship between the defense and ARCA.
Way
We don't
louder.
know about the impact it had on the first trial. There has been these multiple representations that ARCA 24.
So wait, you guys think that sounds better?
Way louder.
What do you guys think?
Am I not being heard?
I'm super loud. Yeah, I can hear you. I'm asking the viewers.
The court is significantly louder. We just have to fix ourselves.
Okay.
I'm turning off my microphone. I'm using my computer.
Does it sound way echoey though?
Open notorious is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those
I turned my
comments are
microphone off.
important. I think what stands out about
Fix the picture.
prior hearings, and I say that I think that
Can you hear me?
Yeah, I can hear you. Am I way
Now I'm
better?
using my computer.
I cranked mine down.
I'm using my computer.
And I thought you
Fix the
knew
picture.
the federal that the defense had no access and no.
What?
Fix the picture.
Okay. Is my mic a little better? I'm all the way down to 13.
I mean, you sound fine to me. I'm using my computer now, so I have no idea if I'm too loud, too soft, or what.
Okay, so we were probably, what were we, about 8 minutes into him?
I don't know. He said there was a raindrop and a
Office regarding
asshole.
their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information, when you compare it.
Are we too far? Let me see where we're at.
You just want to start them over? Because you're going to piss people off now. Oh, no,
I mean-
skip forward to where we left off.
No, somebody said that, no, that I was too far ahead.
I first spoke to the court, I believe the documents provided by the federal government, and I did correct that record as soon.
Okay, so yeah, I'm just gonna start with Brennan like 2 minutes in.
We're right to the point.
Speed them up
And with the
1.25.
sidebar specifically mentioned, I don't know, about here is inconsequential, I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced, all of that was portrayed as baseless. But the court had questions, I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are 2 requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an
What?
affidavit from
The
either
fuck is he talking
either
about?
counsel. We did not hear a word from any of them. According to Mr. Lisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Williams.
It wasn't a request, Your Honor.
You suggested that I.
Yeah.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is, it is not incumbent on the court
Come on,
to
yeah, you
provide
did.
the proof that the defense was given the opportunity to bring in
Fuck.
today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCA's position did not change, it did change. Their opinions did change by the time they reached trial.
What?
It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical. And that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. The first trial was disclosed last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my 2 requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not directly. No bills other than what the ARCA experts did in putting together their demonstration and their accident
Wait,
reconstruction.
can you pause it?
February 11th, I filed on behalf of the Commonwealth.
There is a distinction between the federal discovery and the discovery in this case. Why in what world would a TUI request ever get them information from the experts themselves about the communications between these lawyers? Never. When would it get them a bill from these lawyers? Never. You're only getting the stuff that the federal government was involved in. There's no reason to even think the federal government has any of the stuff that would happen by and between counsel and the experts in this case. So, and his, like, she's really buying into somehow, this shows like a bias. Now, what I do think shows a bias is his request to, I don't have to say that if you don't think I should. That does show a bias. It does.
Well, to me, speaking of bias, the far more disturbing argument for Brennan here is that he's saying that when it became clear to ARCA that their opinion, which was rendered independently, was in line with the defense, that they somehow became biased, which I think is total bullshit. Like
Right.
they had reached, just because it so happened to lean towards
Align with the
being
defense, right?
the defense, and apparently to me is exculpatory, does not mean that they have now become biased. It just so happens that they independently reached the same conclusion that the defense did, which is that
Those injuries did not happen from that car. Right. But she seems to be buying it to a certain
dude,
extent.
I fucking told you. I told you all day. Like, I'm like, the Pro Hawk shit. Like Bev, Like, because when people kept telling me, like, man, she's super biased. She's been dying to get Jackson off this case. I'm like, no, you're being like, Jackson's well respected. Like, I mean,
Well, I said it was excitement.
yeah, I mean, then
If
why
you
are
get
you
'em
so
all.
why are you so surprised if you thought that's what it was?
Well, because I mean, I guess I would be surprised if she wholeheartedly, genuinely found this information could have been so helpful to the defense, short of, I don't need to say that if you don't want me to, but because, Vinny's right. If we had material from a prosecution expert saying, even though it's something, you know, insubstantial, I
He'd
don't
be
have to say
pounding on the table, no
right.
question.
Exactly.
Yeah.
Yeah.
All right, let's.
Well, our motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information, when you compare it to the representations that have been made prior to trial by the defense, that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc v. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc v. attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully, to Attorney Cannone,
Wow.
fine attorney, an excellent
Pause
attorney
it.
who I admire. But there is a responsibility
Babe.
so that there are not a number of pro hoc v. lawyers doing different.
Wow, he's trying to wheel this right into Bederow not being able to get in. I mean, the remedy of this, the whole remedy for all of this, based on his argument right now, could be make Karen Reed hire 2 more local counsel to oversee I guess it'll be 4 pro hoc vici lawyers. But he's trying to circle this right into getting Bederow out.
Yeah, for sure. I mean, he laid that out last time, which I warned you about,
I know.
and you poo-pooed. But
I know.
yeah.
Different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000.
You don't know
pages
shit,
plus.
Judge.
I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the second order. I did ask full counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please. All right, if I can have it, I'd like it. It would help.
Pause it
guide me
again.
Through this. If I can't have it, I'll just go with everything I've done.
May I have a moment to speak to counsel?
Sure.
He's probably saying, I don't think there's anything that would prevent you from turning it over to a court ever. And secondly, it says
Hey, but I have to
about,
pause it.
I'll need to call.
well, it was quiet.
I'm sorry, I couldn't hear a word you were saying.
Oh,
It's
I think
so loud on my end. It's crazy.
Well, turn your sound down.
I can't mess with it. It's like I hear things differently than you and the people out in the audience. It's just it's loud here. Like when I'm getting the boost, it's cranked for me.
Oh, you could probably turn off the boost, because I don't think it's actually boosting for us for
Really?
whatever reason. I told you
I'm
when
not-
you,
like people can hear the court. I'm not messing with it.
I know, but I played it on my end with no boost, and I could hear, I'm like, oh, I can hear it, but that's fine. But if the order says you cannot talk about federal materials, in what world does that mean you can't contact you can contact whoever the F you want. You just can't talk to them about federal materials. You can talk to them about scheduling. You can talk to them about their qualifications. You can talk to them about their background, their, deposition and trial testimony. You just can't talk to them about the federal materials. So what in the hell is he talking about that he couldn't contact them? The reason he couldn't contact them is because he couldn't ask them or wouldn't contact them, is because why the hell he's not allowed to ask them about their testing and findings. So what in what world does he ever want to talk to them? He's got no reason to talk to them. Of course, the party who wants to be able to use them is going to talk to them about everything they can, short of what they can't. Right?
Yeah, 100%. I mean, that's what I was telling you. Like, I'm like, in what world can't you prep your witnesses to go on the stand in a trial?
Prepping them is a different.
How is talking to them and prepping them any different?
Well, because
What are you
prepping them over
talking
and
to them
above their
about, like,
background, their
the upcoming
qualifications.
like the Red Sox season?
No, their
You
qualifications.
have their CV for that. Like, you don't need to talk to them, but like you can read the CV for that. I mean, like, come on, dude. When you're talking to an expert, it's all prep shit. You're asking them questions. You're like,
Right, but I'm saying he's going to ask them as many questions as they can, short of about their actual testing and findings.
yeah, fuck. All right, let's go. Yeah, for me, like you guys are saying it's louder. For me, it's so echoey. It sounds like that he's in a fishbowl.
Can you do me a favor? Turn down the
It
boost. It's
doesn't
not
matter.
going to.
That's what it sounded like before I put a boost on at all. It just
Okay.
sounds like Courts TV. The Boston 10 feeds just better. I think they're the pool camera.
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was
It's a little
rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that was precluded. And so there was not an opportunity.
Funkarella, she snapped at Alisi when Alisi offered to allow Judge Bev to speak to the lawyers in chambers. And she's like, I will never speak to.
No, he suggested that she contact the ASA. I mean, the federal attorney. So the United States attorney. And then he tried to say he didn't, but he most assuredly did.
You're talking about Elise did.
Yes. And he's like, well, I said, if you want to, you should. And I believe he said something like, and I suggest the court should do that or something. He definitely did. So it was weird that he like stood up and then he tried to get up and make another argument before she talked to Attorney Little and she like shut him down.
Okay.
To call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies at the 24 saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like it would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the voir dire where it was asked, were you available to the Commonwealth? And the witness said, yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26
You
of
know
trial.
that, but what date?
June 5th, 2024. Discussing scheduling and voir dire hearings. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the content of the report. And those are definitely questions I'm going to ask. So I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number?
They hadn't talked to him since then. They hadn't talked to them.
Number and the page number.
Day 26 of trial, page 248 to 250. I will get a volume number to the court.
That's okay.
This seems to directly contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing.
That's true.
So this presentation today by Attorney Lisi suggesting somehow that this was open and notorious is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it.
Is he gaslighting me?
But those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, this is June 10th, 2024, trial transcript 28.
Hold on one second.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when we look at the ARCA report, there's no delineation on which of the three experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told, well, you said, so I'm to believe that the defense is calling three witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As was mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls two witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed three experts. So there must be conversations with somebody explaining the witness's role or why only two of those three witnesses are important to the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided.
Babe, pause it. That might be a valid question. So there were three possible witnesses. How did they narrow it down to which two they wanted? He could have had that, you know, it could have been in that telephone discussion that he had, but it does make you think, did the defense know something additional about who did what so that they could determine who to call? Or you can kind of glean it by the titles of the people in the report. You know, Dr. So-and-so, comma, whatever his, you know, his education is. I'm just going to use the words like reconstruction specialist or PhD, blah, blah, blah. You know, he's talking about the body or whatever it is. But he is making a somewhat valid argument, at least as I think of it right now, until I kind of hear more from the defense about.
I had tweeted that I thought it was very telling when Judge Bev was reading what the invoice was for. There was 100% an inflection in her voice when she said the two words trial prep. Now,
Well, right, that was.
But let me finish. When you have her doing that, the next logical leap she's going to make is that there was other communication that took place, because this is trial prep, meaning this is before trial. So meaning that there had to have been communications in her mind between the defense and these witnesses. Otherwise, why are they charging for trial prep? Do you understand the, you
Well,
know,
it depends. There's going to be dates. If it says March 22nd, you know, July, whatever, you know.
I don't know if that invoice read like that. When I was looking at because the DOJ's invoice is available for the entire public because it's the federal government. So they put it out there.
There's no dates.
It did not break it down like that. It wasn't like a lawyer's billing, like, you know, we had a conference call.
Right, but did it give dates at all? Or just say trial prep?
I cannot remember. I don't know.
All right.
I'm not sure. I mean,
but
that's what I was saying, like about going all the way back to if there was some kind of like in a casual conversation where like Wolf and Jackson are like, he's like, yo, I mean, we're gonna have to get paid for this shit at some point. And Jackson's like, I got you. You know what I mean? I mean, is that
well, then that would be a horrible ethical violation of Jackson.
That's what that's why I keep saying I think the defense needs to call Wolf to the stand. Like the judge needs to be able to ask him questions. I don't.
Yeah, but I think she has to accept their
I don't think
assertions.
She has to accept shit. Like the candor of the court is at issue.
Yeah. And they didn't present it as testimony at this point. It's all argument.
I mean, I'm like all over the place. I'm tweeting like first that it looks like Jackson's in peril. Then I listened to Lisi after lunch, and he talks about the misrepresentations. And then I'm like, all right, so I think Lisi cured it. And then Judge Bev, the first words out of her mouth are pro hoc vice, which brings me right back to what I was originally saying. Like, it's the easiest way to dump a lawyer. And you were like, well, you know,
she does still have to find.
But it seems like there might be enough there. Now the question becomes, in terms of somebody's Sixth Amendment right to choice of counsel,
it trumps.
It's got to trump it, right? I mean, but
it does trump
it. There's no question she's entertaining it.
Page on June 18th, 2024. The voir dire hearing.
It's crazy.
The court asks, well, I thought that you would help.
I've got the transcript. What page you want?
It's like exactly what happened to you and Garcia. I mean, different set of circumstances, but like right on the eve of trial, you're like in there, you were trying to even the playing field in terms of the pretrial publicity, you know, but this is another just a crazy case.
Do you know?
No, but I can.
If it's just your notes, that's okay.
I can pull it up.
Oh yeah, you could be crystal clear on this fact. If Jackson's bounced, he's not going quietly, and there's no way this thing's going in the beginning of April. I mean, the concept, he's lead counsel. I mean, make no bones about it. He sits right in the middle. He's the man. So if she's going to pull Karen Reed's lead counsel, whoever comes in, you know, she may try to say some shit like, oh, well, Mr. Yannetti, you've got Mr. Yannetti, Miss Little, and Mr. Alisi, you have plenty of lawyers. I don't know that, you know, I mean, they're going to all argue, because I was making the same argument when you got removed, when they pulled your pro hoc and Garcia. I'm like, well, she's our DNA lawyer. Like my dad.
Don't tell me that you got Bob Sr. and that you need her.
Right.
Like what? You need this peon of a woman?
I'm like, I need her. I need her. Yeah, that's what I'm telling you. I need my partner in all things.
Oh, your client's not going to get as good of legal counsel if she's not involved.
I said, that's right.
You did.
Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the.
You just said I'm going to refrain from my characterizations. but unlike the defense, I think the transcript speaks for itself. He just characterized it. At least he went through all the transcripts and read all the shit. He just characterized it. Wow.
I mean, we already know
Or-
whenever he says he's not about to do something, that he's about to do it. I am not trying to prevent the experts from testifying. I am
mean-
not going to comment on her right to counsel of Bederow. It's his introduction to what he's about to do. She might as well just say the same thing to him. Excuse me, sir, you don't have to tell us what you're going to do by saying it's what you're not going to do before you do it.
Well, let me ask you this. Do you think, and I don't know if you saw it or not, do you think that Judge Bev's one pager, her little order, like midweek, discussing what they were discussing about, this is
I didn't see
straight
it.
up. I just said that. I didn't know if you saw it. It was basically like, this is what we're going to be going through. But my question to you is just, you can imagine what it said. It was relatively short. Do you think that cures the issue? This has turned into a full-on sanction hearing.
Yeah, hence I updated the ticker because
Right. So, I mean, this is right. So this is a full-on sanction hearing. Do you think that cures the due process issues as far as because I mean, clearly they'll be able to argue at least he came in prepared. He made Sixth Amendment arguments. They obviously understood.
Well, what did she write in the thing? I don't know.
I can't remember it, but I mean, everyone was getting the vibe. Everyone was getting the vibe. I mean, I've been saying it like since
I
this
asked
thing
you
went
yesterday if
down,
there had
she's
been any
been-
new any new orders in Reed, and you told me no. So I didn't even.
I don't know if I did that.
Yeah, last night when we were on with Josh.
Are you gaslighting me right now? Oh, thank God I can check. I'll check to see if you're gaslighting me right now.
Yeah.
Right.
Well, look in the transcript.
Well, I'm gonna not make any characterizations because I think the transcript speaks for itself.
Good hearing,
Gaslighter.
page 71.
Yes, he can. Winter.
Okay.
It's like we say things, but people aren't listening.
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked into court, had you and I ever met face to face? No, sir. Now, this illustrates an important point. That is technically
does.
true.
But then why the hell is he
What
killing
impression
him?
is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARCA are wholly independent from each other.
Pause it a sec.
This is also consistent with the representations regarding.
I almost wish that Jackson could argue in rebuttal. I mean, at least he's got his strong points, and I was super impressed with his presentation, early on. But for the flair and the dramatic of all of what this guy just said was bullshit, I feel like you need Yannetti or Jackson. Like, it's like, are we living in some sort of fictional reality where and he said the words, their opinion changed. And she didn't say, counsel, can you point to me any change in their opinion that you believe was influenced by the email saying it was, it was, to follow up on our conversation, I'm going to send out an engagement letter and any retainer as, as required will follow. A follow-up that says, hey, we're going to pause. Okay. Nothing can be used or gleaned from that. It is not anything anything at all. It is literally bullshit. Then you have his qualifications and his background. I still say that is literally nothing bullshit. They already have his CV. The fact that I can call up any expert in the goddamn world right now and sorry, I probably shouldn't have said it like that. I know there's a lot of religious people, and that's rude. So I'm
Wow.
sorry. But I can call anybody in the world, any expert in the world right now, and ask for a copy of their CV and talk to them about their background. I don't, for him to be like, I wasn't allowed to contact them. Well, you weren't allowed to talk about their underlying shit, but you were surely allowed to contact them. You just had no reason to because you don't want to call them and you hate their opinion. I've picked up the phone and called the DNA experts for the state, the state lab people, not their if they um you know to ask for clarification of something, um and the state lab will talk to me, easy. But I just don't understand. Or he's like, he's acting like they're independent, but they had these conversations. There was nothing asked of this expert until he, on his own accord, sent an email with an outline of what he thought the direct should be. And that's because he was not allowed, able, whatever, to do any trial prep. And it's like, how the hell do you put on people without any sort of, without knowing what to ask them in trial prep? I mean, luckily she's got strong lawyers. So I feel like so much of what he's saying is complete and total bullshit. But again, I'm going to, as much as those of you that don't want to hear it, say the offer to not mention something. Although I think at the end of the day, it's really nothing because it didn't go to his underlying opinion, and Jackson put it in anyway. But the mere fact that he says, but I don't need to say that if you don't want me to, or something along those lines, does show some sort of, I'm calling it bias because under the law, everything kind of falls under the bias category, like that he's willing to make what's the word, concessions for the defense, but short of that, I feel like none of what he's saying means anything. And I don't even remember where I started with all of this, what got me all huffy to begin with. So thank you. And that brings an end to this interruption. Back
Good
to your
rant,
original
babe.
broadcast.
Good rant.
Payment. There are questions. This is also consistent with the representations regarding
Now we're going to hear it.
payment. There are questions voir dire and at trial about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them.
God damn it. Their opinion
then it
is
not
independent.
fair representation. It is not an honest
Oh, I said,
representation.
God damn it.
Hey, you said God damn it again.
Sorry. I wonder if I do that a lot more than I realize now that
Yeah, big time.
I apologize to everybody.
It wasn't until Your Honor asked today
I mean on
that
lives.
we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax
Rewind that a
ID
second.
number,
Rewind that a
invoice date
second,
is
babe.
5/12/2024,
Babe.
the rest to
Hold on one second.
Robert Michael,
What?
rewind that a second.
Rewind it?
Yep, 10 seconds. Okay.
Here.
Nothing wrong with going over a direct examination with an
Went a
expert.
little far.
There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest
Here it comes.
representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill.
She's writing.
When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice dated July 12, 2024, it's addressed to.
Hold on 1 second.
When we get to see her and we see when she's writing, that's all
It's
very
addressed
significant.
to Attorney Jackson.
Julie, haven't you been watching this channel long enough to know that I'm tweeting? I'm not sleeping.
I know that's their running joke. That's what they all say about you when you're not looking at the chat to
I
even
think
know.
some people still don't know.
I think they all know. It's just
don't know.
it's like a
You
running
guys
joke.
all know. Are you guys just messing with me?
Ay, shit, but.
I mean, I'm in a Twitter war right now. So, you know, I mean, as you can imagine, I'm waffling. So I've got both sides are infuriated.
And the position that the defense takes, Attorney Lisi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. ARCA experts knew. Dr. Wolf knew. Dr. Rensler apparently knew.
Can she tell him not to
The federal
speculate?
government knew.
How?
When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, and they wouldn't have been keeping track of their time.
That's
back
not
on
true.
May 1st, 2024, participating in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer. And then the 24th saying we need to take a step back because of the U.S. Attorney's Office.
22nd.
I'm sorry, 22nd and 24th. There is obviously more communications because the relationship re-engages at least on or before May 1st, 2024. And these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing where the representations were made, there was a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now being paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or is this solely the preparation of Dr. Rensler on his own? On the same date, 3 hours filled by Dr. Wolf, prepared for testimony and hearing.
Pause it.
Now, they felt.
Now, when we talk about things you can infer, you've got a bill that says, did something and participated in phone call with Alan. I think it's fair to assume if his voir dire prep included a conversation with Alan, it would, I mean, Jackson, I guess he's using his first name. So, but whatever, that there was a conversation with Alan Jackson, that it would say there was a conversation with Alan Jackson. And he can't use, she has to accept their, you know, it would be, I think, highly irregular if these lawyers swear in court as officers of the court that they had no other conversations other than this or whatever the case may be, that she's going to say, I don't believe them. So, but it goes to your point. They should have had Wolf. They should have had Wolf there, but you don't want Wolf. I mean, that opens a real can of worms, you know, like allowing him to be cross-examined on this issue, like laying traps and stuff. But maybe they should have had him there and somehow
I mean, you can only lay traps for people that are lying, though.
No, I know, but lay a trap that they'll try to, use at trial.
I'm just saying it's really hard to trap people that are telling the truth about everything.
Yeah. I think Jackson needs to say more words about these
I mean,
conversations.
they clearly made the decision to have Elise argue it,
because her question was, did you agree with everything he said? So and she actually did them a favor by doing that, because now there is sworn testimony on the, like as officers of the court in open court, they made these statements on the record, where before it was just Elise saying words.
Right. Well, I mean, they've adopted his words.
Right. But she did them a favor, because otherwise they presented no evidence. Under the law and under an appellate court ruling, the defense presented zero evidence in this hearing. Right. Until she asked each lawyer that question. Then they might as well have testified themselves.
Line and comfortable billing the defense for, was
Go
there
back 5
any
seconds.
interaction or discussion between the parties?
Go back
We
5
don't know.
seconds.
This was on the same day, 3 hours billed by Dr. Wolf, prepared for testimony at hearing. Now, they felt inclined and comfortable billing the defense for, was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony. It is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that
No.
time.
Pause it.
Why?
Also billing for wait time and travel, testimony at trial on June.
Because every lawyer knows you need to keep contemporaneous records of your time, even when you're not hourly billing. So, and like you said, for their, I don't know how their practice works, so their business works, but in a law firm, for example, even associates who are not, who are working on, let's say, like a criminal matter, or they're helping a lawyer, so their hours aren't going to be billed. It's something that's not your typical hourly billing. We want to know what the employees are doing, how they're spending their time. So, but I do think there's an issue here, like we discussed it earlier. Did Wolf and the other gentleman, who I can't think of his name because they were both asked, Rentschler, did they think that they were getting paid? And I mean, I guess the only question asked of them was, have we paid you anything? And they said, no, you've paid us nothing. They didn't say not yet, but they can use that on cross-examination to try and, muddy up their credibility, but he's jumping to all sorts of conclusions here. And I'm hoping that he will very succinctly, Alessi will very succinctly, counter all of this.
I mean, I thought we weren't speculating.
Right.
24th, and then there's expenses from June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send within 1 month of the defense that gets paid that Commonwealth and court never knows about. Talking about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness. We have no writing, no email, no correspondence, nothing to support or put in context the conversation, nothing. Nothing. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story, a fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when you look at the totality of representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6. Motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. And what I suggest more 3.6 activity. Quote, no, of course not. That was the position last week. 6.
Hearsay, objection. Wow.
So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial.
I can't believe they let that get
There
in.
have been these multiple representations that ARCA was independent. They had their opinions and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for the sake of the press and the public, we'll have a trial and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question is going to be, why? Why did they improve? Why did they...
Particular page you'd like to...
Thank you, Your Honor. Thank you. That's what I've been saying. If he's going to make an assertion like that, hold his feet to the fire.
Look at the first page.
Yes.
Yeah,
You don't have to read any of it. You just tell me what paragraph.
Here, somebody write this down. You guys in the chat, take notes. No, I'm going to take notes.
Yeah, I think it's just the first paragraph that lays out their findings.
Thank you very much.
And actually, particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page, which is signed by all 3 of the experts, Mr. Wolf, Mr. Renshaw, and Mr. Klein, says essentially the same thing. So we'd be oblivious if we stood here and said that the relationship between the defense and the experts, there was no relevance to bias or motive or desire to please, because clearly There's a change, there's an expectation of payment, there's communication. And to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared, it isn't just what's in that outline. It's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden.
That's the number one
And
point
so
he has.
there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair.
But at the end of the day, their opinion pre-existed this.
So we know
that
there is
still
more.
remains.
The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works.
Also isn't going to get anything that happened
And
between
so,
these parties here.
We are
and
in
the
the same
experts.
spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations or communications the defense had with the ARCA experts that the federal government doesn't know about.
None of it.
Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled. Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be
Oh, what are you trying to be?
overly critical of another attorney.
Okay, overly critical. Got it.
I'm not.
Oh, you are. Got it.
You can laugh, but I'm not.
But
It has been my effort to get Rule 14 material. It has been my effort not to exclude ARCA witnesses.
Oh,
It has been
Lord.
my effort to try to achieve fair play.
I don't want to exclude them. No,
There's been
no.
no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
All right, thank you. Mr. Leslie, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very
Yes.
brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they have been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to be providing testimony. That is a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid
No.
for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference about what he said, that what was said, but that was his response, that was it. But it was only, the premise of Attorney Brennan was, what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things, and I'm going to go through quickly, is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics, Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 ARCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I
Yep.
didn't go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion, way early on.
Who is Mr. Klein?
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
And let me be clear on what I mean by retain. He didn't testify.
It's been a long
I
day.
understand. I'm trying to answer your question, Your Honor.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right, so what I'm saying is, in terms of, I'm gonna take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf.
That's Brennan's
And that's
point.
what I want to come to, Your Honor.
Okay.
The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice.
That's
My
not the
point was,
point.
I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this 3rd person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCA witnesses, because we weren't talking about the 3rd. The 3rd was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you were calling 3 witnesses whom you've never spoken to. When I had that discussion with Mr. Unetti, that's what I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're to believe.
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. That's exactly right. It was June 10th. It's important. He stopped on
page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's
But how'd you get from
100%
3 to
true,
2?
because
I
I
read that earlier.
Right, but Mr. Brennan just mischaracterized it again, because that is 100% true. He made it seem like that was an untruthful statement, and I know
Pause
Your
it.
Honor gets it.
Pause it.
last 2 points, Your Honor.
Pause it.
Attorney Brennan talked about that there's
His point and the judge's point there, and I can't tell how loud or not loud I am, but is that there were 3 possible witnesses, as the judge stated, and as he just conceded, those 3 referred to the 3 potential ARCA witnesses. How did you determine you only wanted to call 2? I think he started to say something about, well, then he didn't continue, he didn't proceed, but he never fleshed it out. The judge wants to know, how did you decide without any conversation, as you claim, substantive about who did what? Did you determine that you were going to call Renkler and Wolf and not Klein? That's what she wants to know. That's the issue with the 3, not whatever point it is he's making it, as I see it.
Right. The inference being that in determining which 2 that you were going to have to call or that you wanted to call, that there had to have been conversations that had taken place
to figure out who did what.
Right.
The ARCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little and I spoke with Mr. Jackson, and they're going to be completely available for any questions that follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Cannone was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the 2 of them, would, if there was any recollection. So during the break, I asked Ms. Little, I said, Ms. Little, when you heard and got the order, because that's the first she knew of the inquiry, she gets the order, I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails? And she said, no. I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back. I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.38. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3A1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question from whether the attorneys are in compliance with 3.3A. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor, which said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it. And I'm going to give you another cite, Your Honor, which is United States versus Diaries, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable. And yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant, their choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brown?
Very briefly.
I mean, doesn't the defense get the final word? What the hell?
My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading.
That was filed
On
late, right? The
February
first Saturday or something.
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Manetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not.
Ms.
right?
Little has
It's
only done the
maybe
certificate of
authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Manetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Daniel Wolf, PhD, and Andrew Rentschler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense. It was not made in good faith. It was a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Alisi no longer likes the word retain, but that retain word has
Still talking about paying for their opinion.
He said their words, their motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court at 9:30 in the morning.
Okay.
Could we possibly go there and then come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so we'll see you next week.
What line, please?
Wow. The dreaded limbo.
Yeah.
Dreaded limbo for Alan Jackson. I mean, look, there is zero doubt in my mind that she is absolutely contemplating booting him.
Okay, so your voice just got louder. Can we
I put mine to automatic, so I just went back to normal.
All right, guys, so adjust your thingies. I'm going to try and fix mine too. I'm going to go back to my mic. Something's going on with my computer right now.
I mean, here's the deal. if she makes the huge move to bounce Jackson, no way this thing's going to trial. There's no way. I mean, there's just it's too big of a hole in the team for for the things that he is focused on in terms of what he's handling, to expect one of the other lawyers to, because like you divvy it up. When you have a trial going, you divvy it up between the attorneys, who's going to handle what, who's going to handle what type of evidence. And how's that? Is that better?
I'm having issues. I'm going to have to get out and get back in, I think.
You sound normal to me.
But my computer's like frozen weird.
Oh, it is.
It won't let me click on things. Maybe it's fixed.
I mean, here's the bottom line. At the end of the day, Elise conceded that there were a couple of violations. I mean, he unequivocally said it. He's like, mistakes were made. And this was during his Sixth Amendment argument. But, at the end of the day, for him, when you're balancing that critical right to counsel of your choice versus what they're looking at here, it would seem that the Sixth Amendment will win out. Now, the way that these things really go, if people don't have an understanding, and I think Josh spoke about this last night, and I love that he brought it up because it's so true, and I talk about it too. Judges aren't just sitting in a room contemplating shit. She will be talking to every judge in that building. She'll be talking to all of her judge friends. This is going because she knows she knows if she's going to pull Jackson from this case, it's going to get appealed. There's no doubt about it. Like, if anybody thinks that Jackson's just going to tuck tail and go back to LA, they're dreaming.
No, and this is one of the, at least like under the Illinois criminal rules, where you can't, defendants don't get interlocutory appeals in criminal cases, and even the state only gets them in very limited circumstances where like the court suppresses all the evidence. You get an you can get an immediate appeal, interlocutory appeal, if your right to counsel has been denied, or your bail. But and I think he should have made that argument a little stronger, babe. I think he should have said that, because he touched on it at the end, like, well, we might not be able to meet this date, but that the court has to balance not only her right to counsel of choice, the continuation of counsel of choice, but her right to a speedy trial.
Yeah.
And her right, not the right of for the victims as well, that this doesn't drag on for no reason. She loves, worrying about victims. But I did want to just touch on Corn Pope. I mean, yeah, he's definitely saying that they colluded, but his main point about this, like them colluding thing, is that he can prove that this relationship establishes they're not independent. They're willing to bend to the defense. They're willing to accommodate the defense with what they say. Even if that's true, at the end of the day, they already had this opinion. And that is all that matters. That is literally all that matters. I think that the judge should allow them to say they were hired by the FBI, so that the jurors know who these experts are, because of what happened. And we haven't even done the live on that yet, but because of the juror who spoke to Aiden and said that they discounted them altogether because they couldn't trust them. They didn't know where they came from. And then also allow the prosecution to then try and, challenge their credibility on those types of communications. The biggest one being, I don't have to say that if you don't need me to, because at the end of the day, all that matters is their opinion was first. But to allow them to use this to challenge credibility when it's really like a lot of it is BS, while they're still not even sure who these people are and how they got involved in the case, is highly prejudicial to the defense.
Yeah, I mean, it's a mess right now. I mean, the fact of the matter is that if she bounces him, which I mean, I feel like she's leaning that way,
I
but
mean, she definitely seems like she's leaning that way, or at least it's still something she is considering.
because there's always that thing where you're like, all right, does she appear to be leaning that way to scare them straight?
No, I
Or
don't
is
think
she,
so. With her
I mean,
questions about is that a pro hoc vici case? But
it's a huge move. It's a
yeah.
huge move.
And Erica M, thank you for your generosity, makes a very good point. First of all, he keeps acting like he was surprised that they spoke when they read that transcript, I don't know how many times, from the 10th, saying, we've spoken with them. We talked to them about scheduling and their background. We've communicated with them. So he knew they were communicating. And yeah, that Klein was not a PhD or was not an engineer. So that could speak to how, why they called who. And I just wish he would have touched on that, because you could tell that the judge was thinking about that. Well, I wish they would have touched on each one of those dates in the billing. No, Your Honor, there was no conversation on May 12th. No, Your Honor, like the fact that they didn't say that almost makes it seem like there might have been some actual communication, because it does beg the question, how do you go from no talking to this guy creating a bill on May 1st? And the answer could have been, well, the United States Attorney's Office told them, yeah, you can go testify for the defense. So they started doing the work. It could be as simple as they call the office and they say, we heard back. ARCA, Wolf, whoever calls one of the lawyer's office and says the United States Attorney's Office said we can testify for you guys. And that re-brings it up. But I don't think it's fair to say that they had substantive, discoverable conversations that that weren't disclosed and somehow would have made a difference.
Yeah, I don't know if it seems to me that Brennan's primary thrust is hearkening back to the trial itself, back to the representation that these two witnesses were truly independent. And what his argument is that they're not. That once it became clear to the defense that their opinion really worked for them in a profound way, and then they started engaging in conversation and it became clear that they were going to testify for them after the voir dire, that changed the dynamic of the relationship, which I'm sure it did. I mean, to your point, it makes not a bit of difference because their opinion is what it is, and it wasn't going to change, and they didn't ask him to change it. However, can you really still make that representation that they're not a hired gun? Because they kind of are.
How?
Because they just are. I mean, like, to make the argument you're making, Allison, you would have to say, okay, every expert we're hiring is saying what we need them to, despite the truth. Right? So, like, which...
Wait, did you just say that even if they weren't hired by the defense, there's still an argument that they're a hired gun?
Well, I think that it gives the impression, once a relationship is built between the defense and that witness, independent or not, that they were no longer independent in the sense that, like, I'm just getting a witness off the street. I haven't had any conversations with them. I mean, that's I'm making.
Right, that's the distinction they're making, the judge and the Commonwealth.
Brennan's argument. That's what
right.
I'm
But
trying to say.
I still think when the defense is saying independent, that they are always meaning their findings, their opinions were independent. Anything I do right now, take the guy to dinner, His findings are already made.
Right.
By
And
him-
again, this is all born out of what you said. And it's the problem that she would not allow them to say who hired them,
Right.
so that it becomes clear to the jury these people were hired long before they knew anything about the defense team or the
True.
Commonwealth.
She created the problem by them having
She
to.
did create the problem.
They wouldn't have needed to do all that. You don't know me. You don't know him. You didn't know us. And we didn't pay you. They wouldn't have needed to like keep
Do any
hammering
of that shit. Right.
Right.
I mean, I'd love to be able to read the protective order from the feds. Like that protective order is kind of like is low key if she gets her hands on it, which it sounds like she's going to.
Mandy Tracy, flag some of any questions we get from
I think
subscribers
it
or
could be
members.
the death knell. Like if there's language in there, strong language in that protective order, which she has not seen, that really limits what can be communicated or payment or anything. Like, I mean, when she gets that thing, I won't be shocked if she ends up removing him and pulling his pro hoc, that thing will be
I mean,
the
and
basis of it.
also I don't remember if I heard them mention, I think it's rule 4.1, because you've got a duty of candor to the court, which is I think the 3.3 that they were referencing. But lawyers also have an ethical duty to not make false statements of fact or misrepresentations to the public at large.
All right,
So
I have to set up this live that's going
all right,
down
you
in
go.
a
I'll
half an
talk.
hour. All right. I love you. And thank
Don't
you guys.
leave.
Thank
Are
you
you
for the
leaving?
generosity.
Or are you setting up the live and coming
I
back?
got to leave out of the studio in order to set up the live.
Oh, are you going to come back?
Yeah, I'll come back.
Okay.
Bye.
So it's definitely an issue that that Jackson made that statement about. Absolutely not. I just don't know. To me, look, people want to say that Bob and I are biased, we're one-sided, but I said this before, like taking off my lawyer hat as a person, when you're asked, did you pay for that testimony? You don't answer absolutely not. Because him taking it to mean like, oh, I paid them to provide the testimony they provided, as though she was asking him if he did something untoward. To me, she was just asking, did you pay these witnesses for their testimony? Yeah, she said, did you pay them for their testimony or to testify? He should have said nothing. He should have just made himself, he should have walked out with his head down and, moved on. But that's definitely an issue. And it is technically an issue that she can consider, even though it didn't happen in the courtroom and it's not candor of the court, because it's to the public. So, and Tracy and Mandy, I was mentioning, if you see any questions from members or subscribers, just to flag them. And I don't know, I'd like to hear some of your thoughts on both sides of this. So Marissa J says, so going forward, does she remove Jackson by order? So yeah, she goes. Sorry, guys. Hold on. For those of you who don't know, I'm recovering from RSV. Much, almost all the way better. So if she does remove him or revoke his pro hoc vici status, that would be in a written court order. Yes. And it would be a drastic move from a judge who has said that she wants things to move forward. Erica's asking, what is a federal protective order? So that's just, it's federal because it came out of a federal court, and it's a protective order is like what you can do with information. So typically it's through discovery, when they share something that you can't share with anyone else. Like, I'm going to give you this information, but unlike the other stuff, you can't mention it. You can't do this. You can't do that. So we don't know what this federal protective order said, but part of it seems to have included that I'm going to disclose to you our expert's report, but you cannot talk to our expert about the federal documents, meaning their report. That does not prevent them from reaching out to them and saying, hey, I understand you can't talk to us about the report, but we obviously want you to testify in our case. How can we make that happen? You can bet your ass if the shoe was on the other foot and the federal, these experts concluded that the car did touch John's body, that the Commonwealth would have been doing that. And for them to say, oh, well, we didn't think why would we think we could contact them at all? Well, you had no reason to contact them because you can't talk to them about their findings if you were going to try and poke holes in it by talking to them. And you don't want to call them. So just calling over to be like, hey, how can we both, like get you to testify here, whatever the case may be. And the other Karen wants to know thoughts on Alessi's point about bias to the defense based on the judge's statement. And she says, I felt like that statement was powerful and arguably potentially, if I can speak, punishment enough. I think it was it was a good argument that he made, and I thought that it was something that they're going to have to deal with. It definitely prejudiced the defendant. When you call their attorneys liars, when you challenge the veracity, the candidness, the integrity of one's counsel, it is the same as challenging their entire case because that's who's presenting it. So I don't know that it's arguably punishment enough. There's fines, there's whatever, there's a number of things she could do if she wanted to, but it's clear. And I don't know, Mandy or Tracy, if you can send me this order, because I think Bob definitely told me she didn't hand down any orders. I was trying to figure out if she had said anything between the 18th and today. Because I'd kind of like to consider that. And I think we've gotten to most of your questions. So like Lee Lou had said, I don't know why he's even bothering. She's made up her mind. She may have her mind made up as the way she wants to go, but that doesn't mean that a strong legal argument couldn't let her know she can't do it. And to tell you the truth, I felt it was lacking in the law. I felt that there is a lot of case law out there about how significant of a Sixth Amendment violation this is, that could have been presented that would have made her think, oh, gee, if I do this, it's going to really turn into a shit show. But at the end of the day, she knows it. I mean, thanks, Tracy. All judges and all lawyers know it. You pull, even though it didn't stop the judge in Richard Allen's case, but you remove somebody's lawyer, and there's going to be, high scrutiny of such a thing. I'm going to pull up just so you guys know. And I don't know, is this it? I don't know. So this order doesn't seem, I don't think this is the, all right, I'm going to pull this up while we're talking about it, but I don't think this is it. I think that this is, if it is, then it doesn't seem to say what I thought it was going to say. Oh, wait, I shared the wrong thing. Oof. Okay. Not good. All right. Let me pull this out so I don't accidentally share the wrong screen again. but my computer's messing with me. What? Did it just do the wrong thing again? Oh no, it's the right thing. Okay. So this is the rulings on the motion. Did she bulk all of those things together? And of course now my computer's gone frozen. So the motion to compel surveillance, she's waiting for the affidavit for Bederow, motion to compel discovery. So that's not it. I'm talking about whatever exists about what they were going to address today. And this is not it. This is not that. But let me stop sharing. So Tracy says, what if ARCA thought the Attorney General was going to pay them? And they say, no, send it to the defense because the contract ended. I mean, that's what Alisi was trying to kind of put out there, that was another possibility. But I don't know, that doesn't seem likely to me that they think the federal government's paying for them to come testify in a state criminal case on behalf of the defendant. And then Erica also says she was the one who questioned his expertise prior to voir dire and precipitated them calling the other two and leaving him out. And that goes back to her earlier comment. And thanks for your generosity, Erica, about how, why they didn't call Klein and addresses the issues on that. Does anyone know what do we have anything that says, does it exist publicly? What Judge Bev sent? He said it was a very short thing about what they were going to be discussing that day today. Unless there's something more that I missed that Tracy sent, but I don't think so. No. Well, maybe we are done here. I don't see any other questions. Thanks to everyone, all the members. I don't know if Jay's still here anymore. Gen X, Jay, Meg, Mary, thanks for your generosity. Jay Silbu, I need my cheaters. Christy Silo, thanks for your generosity. I know we put a lot of these up before. Thank you, Liam. And thanks for your generosity. Jennifer, thanks for your generosity. And don't worry about it. Even just a like and a thumbs up, which, by the way, hopefully, thank you for your generosity, Billy. You guys have all given thumbs up. And thank you, Michelle, for your generosity. She wants to go on the wheel. And I know we put this up earlier about, a CFO of an engineering company, and we never get the correct info on who to bill the government for expert testimony. And, there could have been some part of that. Thanks for your generosity, Gen X, where they did think maybe they were going to they figured, I can guarantee you, they probably assume they're getting paid by someone somewhere. And it's very fair to say, thanks, Liam, that experts don't pay for their own transportation and expenses, and they're out of their own pocket. Thank you, Nashley. I know we thanked Crankin already. Thanks, Kaylee. Right. So from the media posed to Jackson, did you pay for their testimony through the lens of not knowing when the bill was paid as if it was paid before? Although we know now that he, he's claiming that he answered that because he found the question to be outrageous. All right, I think I might get this order. I sent something else out to text. Let's see. Okay, so this is it. My computer. Hey,
Hey.
you're about to leave anyway. You might as well just portal everyone over to you, and we can talk until you start. But here is the order, or whatever you want to call it, that the judge put out before. So, prepared to address issues related to defendant's recent production pursuant to Rule 14, especially as the materials produced relate to prior representations made to the court on the record by defense counsel concerning the ARCA witnesses. So it was very vague. In addition, because the Commonwealth referenced a transcript in the hearing of June 10th, at the hearing on February 18th, the Commonwealth is to provide a copy of that transcript. So, I mean, basically, she just says, as it relates to prior representations made to the court on the record.
It smacks of the same shit that happened to Andrew Baldwin and Rosie.
Yeah.
Like, there's all the indications that the judge is seriously contemplating bouncing them from the case. But she, like, there is no sua sponte motion. There was no motion made by Brennan. It's not on the table. It hasn't been asked for yet.
No, it's her sua sponte motion. It is her. I mean, when she says, I guess the question people are having is that notice enough? And that was what you were talking about earlier.
I didn't think it was enough then. Like the assumption that well, you addressed it, so you must have known. I don't think that that's ample notice.
But this judge said, she wrote, be prepared to address the documents as it relates to representations made to the court on the record by defense counsel concerning the ARCA witnesses. That, coupled with this could have grave consequences to the defense,
but
I think is...
In the law, we're not supposed to have to read through the tea leaves. There's notice, there's proper notice. Due process requires, if she's going to try to bounce them, because this was at best a bifurcated hearing. This was dealing with candor, and it was also dealing with discovery issues. And it was only supposed to be ever about discovery issues and potential
right, but like
violation.
You said, he came prepared. He's citing Gonzalez Lopez. He's talking about candor to the court. I mean, that's what they addressed. But for those of you,
but maybe he's calling, if it's a straight up motion for sanctions for removal, maybe he's handling it differently, because that Sixth Amendment shit out of 6 hours,
right,
was
Agreed.
10 minutes. It was a toss in.
Agreed.
So, I don't know.
And it could be that she considers this to be sort of a prelim to whether or not she's going to tell them that she's holding a sua sponte motion to remove counsel, or whatever the case may be, a sanctions hearing. For those of you that don't know, Bob is involved in a new podcast that is highly successful, Murder on Songbird Road. If you haven't listened to it, you should. And if you're still hanging around here in the next 13 minutes, you'll get portaled over to Bob and the host, Lauren Bright Pachenko's insider discussion here about the last episode that came out on Tuesday, right? Oh,
Yeah,
today's Tuesday.
yeah.
Or is it the one that's
It comes out on Thursdays, every Thursday. So I think
So you're-
episode 8 dropped this last week, which was last Thursday.
so that's what you'll be talking about.
Yeah, I mean, Tracy, you're asking questions like, why doesn't the Commonwealth have to do anything? Why isn't the Commonwealth ever admonished? Why aren't they ever, given a good talking to? Why aren't they ever, why? Like, it's frustrating. I get
Well,
it, but
here the defense should have had affidavits.
here's
That's
what
who
the
should have had
prob-
affidavits
Well,
this time.
right, but like the one thing that you can never do that's not a successful road to defending is exactly what I just did, which is okay, but what about them? But what about okay, we may have done something here, but what about them? You didn't do shit to them. It's not fair. Like that's not a winning argument in a court of law. The two wrongs don't make a right thing. There was a bit of that Alisi went through. He's like, but his wasn't really that. His was that the misrepresentations made by Brennan cast that entire day in a very different light right from the get, which I think is true. I was saying that. I'm like, as soon as Brennan makes the misstatement or misrepresentation of who turned over the discovery, it set her off. It put her in a mindset that she would never recover from that day. And I don't know that she's recovered from now.
Right.
So, I mean,
And
it's
Amy, thank you for your generosity. It does seem Bev wants Jackson gone. She loved Alisi. I there's a lot about Alisi I loved, and then there was some things that I didn't love. And just to go back to Tracy, if this would have been the Commonwealth's motion for sanctions, absolutely. He would need
he
affidavits.
hasn't filed an affidavit in anything.
Well, I think they
Brennan.
called him out on something. But now that I've seen what the judge said, she said she wanted them to be prepared to address this. So yeah, this is not their I would agree with you, babe, that this is not their proper notice, due process, that that this is a hearing, a sanctions hearing, which at the end of which she could decide to, remove them as counsel or revoke someone's pro hoc vici. I do think what this is going to end up being, and I just said it earlier, is sort of like her deciding whether she wants to sua sponte set a sanction hearing, a possible removal hearing. I don't think that she will do it based on this alone. I think she will take that extra step because she knows damn well it's going to be scrutinized, so I think that if she's, I think this might have been for her to decide whether or not she, she wanted to sua sponte seek, hold such a hearing, either for sanctions or for removal or to revoke.
I mean, it's identical to what happened in the Allen case. I'm telling you, it's like there were some emails back and forth. They sounded
clearer emails.
There were threats of, I think I'm going to file a motion for sanctions, but it never happened. Like, so if it didn't have, people talk about doing shit all the time. Doing it is a whole different thing. And when you do it, when you file, what that does is it triggers the ability for the other side to be able to respond in writing.
Right. Like I'm going to have Wolf here. Right. I'm going to have Wolf here. I'm going to call witnesses.
Right.
I agree. But I do think that
pulling teeth, getting you to agree with me and shit.
No, but I do think that she will take that additional. I think there'll be more due process before she removes or revokes pro hoc vici status. I do think that.
Well, and I'll tell you what, like I said, if you don't think Cannone is going to be talking to everybody, because it's a huge move.
Huge.
To boot Jackson from this case. Huge. In a lot of different ways. It kicks the trial date. It sets up a big appellate battle. It sets up the possibility that he gets brought back in. It sets up them refiling motions for bias, like all the shit that'll come along with it. And it will come. It will come because I don't know Alan Jackson from a hole in the ground, but I know this much. That dude's not getting booted off a case.
And Karen's not allowing him to get booted. That's
Right.
really, at the end of the day, what matters. Karen's not having her lead counsel booted from the case without a fight. I mean,
Right.
she's not in custody. It doesn't hurt her to keep for that it's going to take longer. It's all money, I guess, really, at the end of the day. And she's got a lot of public money. And then Marissa, why the judge took so many breaks, I'm not even going to speculate, because it could very well be she had to go to the bathroom. I remember one time it was, like if it's a woman's got their period and they're on trial, you may need a lot of breaks. So it could be something very simple. So I don't want to speculate on that. Wait,
Yeah.
who said that Jackson is pro bono?
Well, this go around, they said they're not taking a dime.
Oh, wow.
So, yeah, all of them. None of them are.
Jeez.
I don't know if they've entered their appearances pro bono, or if they're just like, we're not.
Well, you don't have to. That's
Right.
not a special appearance. I'm doing this pro bono. I'm
doing this for free.
Right. That's not something that gets noted one way or another.
All right. So did you thank everybody? All right, you guys.
I did.
You guys have been amazing. I have portaled if anybody's interested, and I hope that you will be.
I figured if we kept them until 5.
I gotta like unwind for.
All right, you go unwind, and then I'll end it right at 5, and they'll be over at you.
Okay.
Ready to start.
All right, y'all. Don't forget, please, on the way out, please share, like, subscribe, and comment if you're on replay, crew, because that definitely helps get it in the algo. Like, share, subscribe, and comment. Bye.
Remy says that that even Bederow is coming in pro bono. I mean, those two weren't paid the first time around. I'll tell you, of like the high profile cases, things you see, trials you see on TV, you often hear the lawyers saying that did not translate. Financially, it wasn't worth it. Like, it didn't turn into a bunch more clients. It did, so it's kind of surprising. I was just checking to see if there were any more super chats. I want to make sure I always address all of those. But look, a lot came of this today. A lot can be told. You can tell a lot by the judge's questions. And again, like the little bit of times that we saw her taking notes and what she was focused on. But I don't think, no matter which side of this you are on, unless you're just dug in and being disingenuous, I don't think there is anything that came out today or that could come out that changes the fact that these experts came to their conclusions wholly independent of the defense. And like Bob said, yeah, there's, when you're saying independent, what does that mean? We talked about it on live yesterday with Josh. You don't get this ever in your career where some agency who was not retained by either party to the action did an investigation. It never happens. So it's like, a gift when you've got exculpatory evidence that comes from an expert hired by the FBI. It's insane. And the way that you can tell how scared the Commonwealth is by all of their, I'm not trying to exclude their lawyers. I'm not trying to exclude their experts, but hey, judge, can you exclude, Bederow? Can you maybe, look at the ethical violations of these lawyers? And, I don't know, can we really trust these experts to testify? So, but I honestly have more faith that Judge Cannone is going to do something different here. She's not going to just this be the end of it and decide to remove their lawyers, but I obviously won't be surprised if it happens, But I appreciate all of you guys. It's been a long Karen Reed day. I've gotten to all your super sticker questions. So thank you all for your generosity. Thank you, mods, for all you do. And I hope everybody hangs around and listens to Lauren and Bob on Murder on Songbird Road. It's an amazing podcast. If you haven't listened to it, go listen to it. Like Bob said, don't forget to give the stream a thumbs up. It's free and it really helps. Thanks, guys. See you guys all, I don't know, tomorrow, probably. All right. Bye.